Okay, good morning, everyone. Thank you so much for coming to our engagement today. It is a collaboration between the South African Human Rights Commission, Cliffe Dekker Hofmeyr, the probono.org, and Lawyers for Human Rights. So the legal symposium is based on migrants' rights. So we will have engagements or presentations from various people, as you see on the program. So to start it off, I am Andile Msane. I am the Human Rights Officer from the South African Human Rights Commission. Okay, so now I will be handing it over to Tanya, who will then take over the program. Thank you so much, and welcome to the Legal Symposium.
Okay. Good morning again, and welcome. To kick things off, we are pleased to have Ms. Zamantungwa Mbeki from the South African Human Rights Commission to give opening remarks and the keynote address on upholding migrant rights in South Africa. Please welcome Ms. Zamantungwa.
Every time this happens, I'm always shocked, as if I don't know. Ladies and gentlemen, first and foremost, welcome to the South African Human Rights Commission, the Gauteng Provincial Office. Firstly, thank you to the team for putting this together. Andile has been talking about it for a long time, and I just said, run with it, I trust you. You'll just send me the bill at the end of the event, but I'm glad that it has turned out so well and that we've got so many esteemed colleagues sitting around the table. We'll imagine that it is one table. I think it's important to note and acknowledge the diverse group that we have today, which just shows the importance of this subject and how it intersects with just about all the work that we do. The Gauteng Provincial Office, as many of the offices in the SAHRC, is constantly inundated with complaints that we have relating to, in essence, the right to citizenship. And as we go, we see how the impact that it has when you do not know where you belong. And that is the subject of today. If we look at it through the lens of belonging, everybody has a sense of belonging, and from belonging, we find community. And we've understood, as we see what is going on around the world, the impact of people who do not belong. We see wars where we are fighting because we say we do not belong. We understand, more importantly, in our country, South Africa, our issues historically of belonging, but they have transformed and they find different identity for our generation. In this day and age, we understand what it is and what it means for us to belong. I remember one of the cases that we had of somebody who has a blocked ID. They've had a blocked ID for close to 25 years. And for 25 years, their problem was not resolved. They came to the commission from Nelspruit, and they came to our Gauteng office. 2 weeks later, he died. When he died, his death could not be registered. So for 25 years, this man lived with no identity, and he died without an identity. His siblings had identity documents. His children had identity documents. His wife had an identity document, but he died without an identity document, and the family struggled to even bury him because he didn't have that identity document. So the context of migration, as we understand it, is not just how we look at it about just having a document, but it's also the consequences, particularly in our country, of not having one. Your bank account being frozen, not being able to get a SASSA grant, not being able to vote, police brutality, unlawful arrests, detention, your children not being able to go to school. So when we look at migration and the consequences of not having an identity or citizenship, we also see the challenges of it and how it impacts just your right to live and being able to move freely. And in essence, you will be deprived of your liberty. So it's a very serious subject. And looking at what we will be discussing today, the presentations today will be looking at every facet of migration. I've just highlighted one aspect, which is identity documents, but we will be looking at different aspects. I know so many of my colleagues here, when we were working at LRC, we did so much work for under the Refugees Act. People who left their countries to come seek refuge in our country and the challenges that they are facing. So when we look at the issue of migration, we really are looking at number of key pieces of legislation. We're looking at not just those pieces of legislation on their own, but most importantly, we see the consequences of what happens when acts or legislation is not applied accurately, and how it impacts the right to dignity and the right to life of those individuals. And those individuals are not just numbers. They are people that, for so many of us who work in frontline work in the civil society, an attorney in immigration law, when we encounter those people, we encounter really the impact of that on their lives and on their generations to come. So we hope that today you will be changed, but you will know more. You will know more than what you knew when you walked in through our doors this morning. Ladies and gentlemen, I think the symposium is now officially opened. Please enjoy.
Thank you very much, Zamantungwa. Our first session will therefore focus on immigration detention. Our speaker, Nyeleti Baloyi, will guide us through the legal and human rights framework, and she will therefore dive into recent developments and best practices in immigration detention. Please welcome Nyeleti Baloyi.
Thank you all so much. I'm very grateful to be here, and I'm very grateful to have everybody here. I've been very excited about this symposium, to be in a room of legal practitioners and discussing this very important work. Yes, I think this is a fundamental session that we are having today, and hopefully it will go beyond and it will actually impact the lives of a lot of vulnerable populations. So, as mentioned, my name is Nyeleti Baloyi. Hope you can see me. I should have worn heels. I'm a little short. I am an attorney at Lawyers for Human Rights in the Penal Reform and Detention Monitoring Program. And today I will be talking specifically about immigration detention in South Africa. If we can go to the next slide. A brief overview of what I will be speaking about. I will be particularly focusing on the legal framework when it comes to immigration detention. This includes the Immigration Act, the Refugee Act, and other constitutional rights considerations. I will then delve into the recent developments, important case law, legislative changes, and then I will talk on the best practices that, as the Penal Reform and Detention Monitoring Program, have found to work. Also inviting discussions from representatives present to share their best practices as well. Talk about the legal remedies that are available and some ethical consideration. And then finally, and I think most importantly, what I would like to talk about is the collaboration of the people in this room by creating a referral network system, collaborating particularly with Legal Aid South Africa, with private attorneys and advocates, as well as NGO organizations like our LRC. So just to begin, I'd like us to look at what the South African immigration landscape actually looks like. So South Africa has a very complex and dynamic landscape when it comes to immigration detention. As we all know, I'm very sorry if I will be saying things that everybody knows, but there are some people who are not well versed, or they do not focus on this particular aspect of law. But essentially, South Africa has a history of migration from within the continent as well as beyond. And my colleague Homozo, when she speaks about refugee law, asylum law, she will delve more into that. But South Africa historically has been welcoming a lot of migrants from within the African continent as well as beyond the continent. And while South Africa post-apartheid and into the democratic regime, or the democratic process, have adopted international law, and South Africa's legislation theoretically protects the right to seek asylum. The reality on the ground is that the reality on the ground is that there are persistent and problematic immigration detention practices that exist. I'm sure everybody knows about the Lindela Repatriation Center, which is the sole center in South Africa that houses immigrants for the purposes of detention in order to deport them. And a lot of those people who are housed in that particular facility face a lot of human rights violations. There are a lot of arbitrary arrests that happen in immigration detention. I'll delve more into that when I speak about the legislation. There are a lot of abuse of power by states, including the South African police, as well as the Department of Home Affairs personnel. There is there's a climate of fear that exists within the immigration detention. A lot of people live in constant fear of possibly being arrested, and there are a lot of systematic failures. There are gaps in legal protection in our existing legislation, and as well as there is failures in practical implementation of the existing legislation. So there's a lot of vulnerability, there's a lot of homophobia that exists in this space, and a lot of xenophobia that obviously increases the vulnerability of migrants. So what exactly is immigration detention? So immigration detention is a global phenomenon. It occurs when one form or another It occurs in one form or another in all liberal democratic states, not just in certain states. International human rights bodies have defined immigration detention as the holding in detention of individuals suspected of illegal entry, unauthorized arrival, visa violations, and those that are subject to procedures for deportation and removal. And detention can happen in various forms. It can happen in police stations, and as I've mentioned, in South Africa particularly, it happens at the Lindela Center. But it also happens in a variety of other ways that may not be identified. For example, when it comes to children, what we have found is that detention occurs by the taking away of children from their parents and putting them in DSD facilities just because the parents are undocumented, and therefore then the children are taken away from their parents and technically are detained in these facilities. I'll discuss a case study a bit later. Now, if we can move on to the legal framework when it comes to immigration detention, the key legislative considerations here would be the Immigration Act, and that would be sections 34 of the Immigration Act, which particularly deals with administrative detention. And this is actually fed into by Section 41 of the Immigration Act, which particularly allows immigration officials and South African police officials to stop people and inquire about their documentation status. And after that inquiry, it can lead to either a Section 34 detention or a Section 49 detention. So with the Section 34 detention, what happens is that a person is taken into custody and they are then questioned on their documentation status, and this can happen to a variety of people. It doesn't just happen to undocumented migrants. Anybody can be stopped and questioned with regards to their documentation. We've had cases where recognized refugees are stopped, people holding ZEP permits are stopped, people who are South Africans but are unable to prove their identity, as Ms. Mbeki stated, because their identification documents have been blocked, or their births were never registered. So that this Section 41 affects everybody, essentially. And when it comes to Section 34, what then happens is that a person would be arrested, and then they would be detained at a specific or determined place of detention for the purposes of deportation. These are various police stations across South Africa that have been identified and have been labeled as places of detention for the purposes of deportation. And historically, what used to happen is that Section 34 allowed for a immigration official or a police official to arrest a person and then have the discretion of whether they bring this person before a judicial officer or not. And then they would then stay in detention arbitrarily. So this was the status of a lot of people who were detained in terms of Section 34. That has currently been challenged. So the relevant cases here are the Lawyers for Human Rights versus Minister of Home Affairs matter. It's a 2018 matter, and as well as the ex parte Minister of Home Affairs in relation to the same case matter, where the Constitutional Court had to determine the legality of Section 34(1), particularly, which allowed for the discretionary position of immigration officials to choose whether to bring a person before a judicial officer or not. And currently what the status is that the Constitutional Court has ordered that discretionary provision is unconstitutional, and therefore anyone who is detained, even if they are being detained in accordance to the administrative detention, which is Section 34, has to be brought before court within 48 hours. This is not the reality, though. Even though the court has ordered that, we are all aware that a lot of police officials would not know that because maybe this has not circulated to them, or immigration officials are not in touch with judicial or jurisprudence involvement. So that is one of the challenges that we still face. And then when it comes to Section 49 offenses or cases of detention, those are particularly criminal detentions. So those would somewhat be straightforward, but essentially a person would be arrested and charged with a criminal offense of being in the country irregularly or of contravening the Immigration Act, and then they would be charged with that particular offense, and they would be kept in detention pending the outcome of that. And yeah, a lot of the times people usually would just plead guilty in those cases, even if they are refugees, recognized refugees, or asylum seekers who are still have not had access to the refugee system. So the Refugee Act is also very relevant. My colleague Homazo will delve more into that, but the particular importance of the intersection between the Refugee Act And the Immigration Act is of particular importance because if you look at the Refugee Act, I think it is in, okay, sorry. Okay, so in section 23 of the Refugee Act, as read with section 29 of the Refugee Act, particularly makes provisions when it comes to considerations of detention of asylum seekers and refugees. And it is very clear there that, let me just quote it. So in section 29, it imposes limitations on detention, mandating that it be reasonable and justifiable, requiring judicial review for detention exceeding 30 days and every subsequent 30-day period, and also stipulating that the detention of children particularly must be a measure of last resort for the shortest possible time, prioritizing family unity and the child's best interest. So now I'd like to delve into particular case law that is relevant. So I've mentioned Lawyers for Human Rights versus the Minister of Home Affairs. So this particular case challenged the constitutionality of the arbitrary detention that was allowed by that provision in section 34.1. So the big issue here in practice that we've come across is that even though now the Constitutional Court has ordered that people be brought before a judicial officer to determine whether or to confirm the detention of a person, what happens in practice is that because this is essentially a civil matter and not a criminal matter, a lot of people are not represented. And this is particularly because these arrests currently do not fall within the ambit of Legal Aid South Africa. And so what usually happens, what I've seen is that people are not even brought before open court. Particularly in Messina, what I have seen is that people are taken into chambers to confirm their detention. They're taken into chambers, they're not provided with interpretation, they're not provided with legal representation, and essentially the judicial officer would just, confirm the detention without actually hearing what the merits of the matter is, or considering why the person is in South Africa, what their position is, and a lot of those matters are what end up in Lindela. So these are people who are taken from the street and arrested and kept in detention, or these are what is also increasingly happening is recognized asylum seekers, people who would have an asylum seeker permit, but I'm sure Khomotso will delve more into this. But a person would have an asylum seeker permit, their case would be considered, and in most likeliness, their case would be rejected. Particularly, I can speak with regards to the Messina RRO, where they have 100% rejection rate. So if you think about that, how could that possibly be true, that everybody who comes through the Bay Bridge border or goes to the RRO in Messina does not have a valid claim to asylum? These are people who are coming from the DRC. These are people who are coming from South Sudan. They would go to the RRO, they would get the asylum, the temporary asylum permit, but essentially, and actually the Messina RRO has a very fast turnaround time. So they would consider your case very quickly, but what would happen most likely is that your case would be rejected. So that would mean then, if your case is then rejected, you are offered an opportunity to appeal. Khomotso will deal with that. You appeal the matter, and that appeal is also rejected. And upon receiving the response that your application has been finally rejected, what would happen, or what has been happening, especially in the last year, is that instead of being given an opportunity to leave the country or to bring a judicial review of the outcome of the appeal, you would then be detained at the RRO. You'd be taken from the RRO and then taken to the magistrate court, where In some instances, you are brought before the judicial officers in chambers, and you don't have access to legal representation, and therefore then you are arbitrarily detained, and then after a few days staying at the police station in Messina, you would then be taken to Lindela. This is what is happening across the country, but maybe colleagues would have different situations that they've come across. So essentially, the challenge of the constitutionality of Section 34 has led to, or well, the Constitutional Court held that the Department of Home Affairs had to amend the legislation to be in line with constitutional values, as particularly Section 35 of the Constitution, the right to be brought before court within 48 hours. But the court in the ex parte matter, where the Department of Home Affairs was challenging the timeframes of actually implementing the legislative challenges or changes, the court further held a particular provision that is of importance, which is the interest of justice consideration. So the court there held that when an immigration official or the detention of a person is being considered in terms of Section 34, before that person is kept in detention, one of the things that needs to be considered is whether it would be in the best interest of justice to keep that person in detention. The challenge there, though, is that there is no explanation as to what the interest of justice would be or would mean, because unlike with a Section 49 matter, the Criminal Procedure Act states that out in detail as what is considered to be in the best interest of justice. So the Department of Home Affairs then implemented the Immigration Amendment Bill, which was released sometime last year, and in November last year called for the submissions on the immigration bill. Now, one of the challenges that we came across within the immigration bill is that, firstly, it did not delve into detail as to what it would mean to be in the best interest of justice for somebody not to be kept in detention. There were also various challenges that were brought by colleagues, particularly the Center for Child Law and Scalabrini Center of Cape Town, that dealt with the challenges that would be that would impact children. Particularly children in detention, which does happen often. Some of the cases that we've come across is that the age consideration or determination of children is not well regulated. So if a child who is undocumented is detained or is arrested and brought before court, it's very difficult to actually determine if this person is a child or not. Especially when it comes to unaccompanied and separated children. So those are some of the challenges that we've come across. We've had a child who actually had a birth certificate from their home country, who was detained and convicted as an adult and taken to Sun City to serve a sentence as an adult. When we eventually intervened, when the matter came through our hotline and we were able to actually secure the birth certificate and make everybody aware of the fact that this is a child, 16-year-old child, that was being kept in detention with adults, that was a very heartbreaking case in the fact that, so one of the remedies that we would usually bring in immigration detention when somebody is facing refoulement, which is a very important principle that Homozo will delve into. One of the remedies that we have found to be very successful is to bring urgent application in the High Court to halt deportation practices. So in that event, the child was already convicted, wrongfully so, because the matter was dealt with as if the child is an adult. The child was convicted and kept in detention in Sun City. We intervened. We managed to get the child out of Sun City into a place of safety. But when the technical sentence of the child lapsed, the child was taken from the place of detention and placed in a police station which usually a person would be kept either at the police station or in Lindela for a couple of months before they are eventually deported. But with that particular case, we had launched an urgent application in the High Court, and miraculously, that child was deported within days before we could actually go to the High Court. So those are some of the challenges that we face. And then another relevant matter is the Scalabrini Center of Cape Town versus Minister of Home Affairs matter, which the Scalabrini Center is being represented by Lawyers for Human Rights. And essentially, this case is as a result of the constitutional case of Ashibo versus the Minister of Home Affairs. So I'm sorry if I'm all over the place, but before the Ashibo case, we had the Ruta versus the Minister of Home Affairs matter, where the Constitutional Court in the Ruta matter affirmed the right to asylum and essentially made it clear that any person who has the intention to apply for asylum needs to be given the opportunity to do so. That was elaborated in Ruta. And then when the Ashibo case happened in the Constitutional Court, the court further affirmed the right to apply for asylum, however, with the caveat that just because somebody has the intention or expresses the intention to apply for asylum doesn't automatically mean that they should be released from custody. And that also made mention of the interest of justice criteria. So that has then led to a lot of people then, or it led to a shift by the Department of Home Affairs, making use of relevant provisions of the Refugee Act to bring a good cause interview. So what would happen is that instead of allowing people to actually to apply for asylum, what they would do is to have an inquiry beforehand to ask as to why did you not come through a port of entry, for example, or why do you not have a travel document to enable you to go to an RRO? And they would then determine that you do not have a good cause as to why you entered the country, and therefore detain you for deportation before actually having access to the asylum system. And that is the challenge of the Scalabrini matter, where the High Court in the Western Cape held. So there's two parts of this particular matter. The first case is to the court ordered that people should still be allowed to apply for asylum, and that anybody who has an intention to apply for asylum should not be deported, and therefore preventing refoulement. However, the challenge with that, which is the second consideration, is that people are still not being actually given access to the refugee system. The practice has been for a while that, or since about November 2023, after the good cause inquiries were started, is that people are actually not having access to the RROs. I'm sure Kumoto will speak more into that. So those are just some of the relevant legal frameworks that are applicable in immigration detention. Now, one of the other things that I wanted to talk about was the best practices. And the first thing that I would want us to consider when dealing with these matters is the first step, when you're actually approached by a client and you actually have to have an assessment or an interview or a consultation with the client. So one of the most difficult hurdles that we have found in conducting effective consultations with individuals in immigration detention is that there is a pervasive language barrier, because a lot of people are coming from countries where English is not the main language that is spoken there, as well as the fact that a lot of detainees come from situations that have led to a lot of trauma. So beyond language barrier, there's profound traumatic experience by many detainees. which presents a complex challenge. So many people come because they have fled wars, they've fled persecution, violence, and other harrowing circumstances. And these experiences can leave deep psychological scars, manifesting in various ways. A lot of that is that people don't want to relieve some of those traumas. So even in the interview, a lot of detainees will leave out a lot of details that are pertinent because they don't want to relieve those traumas. Other ways that this manifests is that a lot of what I found, a lot of clients would express that they came into South Africa because they want greener pastures, right? And then when you ask them, okay, but what was happening in your country? They'll be like, no, nothing was, there's war, and that's about it. And not delve into the fact that my next door neighbor was bombed, right? And they see that as just normal, or half of my family was slaughtered. They wouldn't see that as an extreme thing that is worth mentioning, because for them that's just everyday life. So those are some of the things that we need to consider when we are interviewing some of these migrant, especially refugees. And then some of the legal remedies that I've already talked about is participating in legal reform, participating in making representation when, for example, legislation is presented for amendment. It's very important that we make contribution to shape the law, to inform the rights of vulnerable people. So another thing that is of particular importance that we think is very it's not very well utilized when it comes to immigration detention is the application of the bail procedure or the bail process. So what we have found is that in a lot of courts, what would happen is that legal practitioners would not even consider applying for bail because this person is undocumented, for example. So they'll say, why would I apply for bail if this person doesn't even have documents? Whereas this is a very effective way to actually, especially for asylum seekers and refugees, to effect alternatives to detention, which I'll delve into more shortly. But the bail process is very effective when it comes to immigration detention. So before I was, in my previous life, before I was at Lawyers for Human Rights, I was actually a legal aid candidate attorney. So legal aid formed me. And in my experience, I found that it was very difficult to deal with immigration matters because a lot of the people in the room, stakeholders in magistrate courts, are not aware of the asylum process or refugee law particularly. So what would happen is that the immigration officer would come there and would be the expert and would tell everybody that this person cannot be released. And they would cite the Immigration Act and then say it is a crime to assist anybody who is an illegal migrant in South Africa to be released, right? And that would be the end of it. And there would be no consideration of why has this person come into South Africa? Why are they undocumented? So I think bail applications are underutilized when it comes to immigration detentions in our courts because if you look at the consideration of what is in the best interest of justice, the many caveats that allow, okay, if a person is undocumented, there's still other ways to determine who this person is, right? If a person is a part of a community here in Johannesburg, for example, they have lived in this particular address for a significant amount of time, they have children, they go to church here, there's no reason as to why you would say this person is untraceable. Also, there are other provisions. You can ask that this person report to a police station. So that's just one of the examples that alternatives to detention can be used in matters of immigration detention. Other ways or procedures that we use, particularly in magistrate courts, is that if a person is an asylum seeker or a refugee and they have been arrested, instead of going through with the criminal system or going through with trial, what we would do is would immediately make representations for this person, outlining the fact that they are a asylum seeker and they are a refugee, and basically explaining how the prospects of success of this matter would not be possible because the person is protected under refugee law in South Africa and international law. If anybody is interested, I can share some of those precedents of representations. And in a lot of the cases where people are actual genuine asylum seekers or they have asylum papers, where in a lot of cases those papers have expired. And those people have made efforts to renew those permits, but because of the system of Department of Home Affairs, have been unable to renew those papers. In a lot of those cases, when we make representations, they are successful and people are released and given an opportunity then to go and apply or renew their papers. However, it is not always the case. In some circumstances, even if people are genuine refugees, the representations are unsuccessful, and then you would then have to go to trial. And this is something that we should consider, and we shouldn't turn away from just because, for example, a person doesn't have any documentation. Take into consideration this person, let's say they are from the DRC, have a genuine claim for asylum, and also to consider the fact that, as the court emphasized in the Ruta judgment, that the consideration of whether a person is a refugee or not is the sole job of a refugee status determination officer. So it's not for an arresting immigration officer to say, no, you don't have a genuine claim. It's not for the court either to say, no, you are in South Africa, but you want to claim for asylum, but your claim is not genuine. It's not for the court to determine. If a person has the intention to apply for asylum, the person who needs to consider the merits of that case is the refugee status determination officer, and they need to be given an opportunity to do so. Okay, if we can move on to the next slide on alternatives to detention. So one of the things that we'd like to advocate for, particularly in immigration detention, is the move away from the criminalization of migration. Migration is a phenomenon that is as old as time. A lot of us are here because we migrated from one place or another, or our great grandfathers migrated from one place to another. So the problem in South Africa is that immigration detention system is very punitive. It criminalizes the movement of people. And despite its administrative intent, it violates international human rights law, which mandates that detention should be a measure of last resort. So that is one of the things that we advocate for, that we consider alternatives to detention. I've already made mention of the bail system, but there are also other forms of alternatives to detention that exist across the globe. For example, in countries such as Hong Kong, Canada, when I was working with the IOM in last year, we had a workshop in Zimbabwe where I learned that in countries such as in countries such as Colombia, for example, when they had a great influx of Venezuelans into Colombia, they actually never used detention as a way to actually regulate that influx. And there are actually good examples in Belgium, for example. I mentioned Colombia because Colombia is not like a Western country and it's not a well-developed country, that in a country like that, they are able to use alternatives to detention and not criminalize the movement of people. In other countries, in Belgium, there are great examples of alternatives to detention. In Africa, in Zambia, they have great examples of alternatives to detention. So some of the propositions that we have to alternatives to detention in South Africa is having a network of open accommodation options where there are communities that people can go into. For example, DRC, they already exist, they're just not formalized, where there are communities of a particular nation that exists in South Africa that is open to accepting asylum seekers from their countries. Another example is the in-person reporting. If a person legitimacy in South Africa is being challenged, the person can report to, for example, a police station to say, I am still here. While you process whether my legitimacy to be in the country, I will continuously make myself available to you so that you know that I am still in the country, or I am still available to the judicial system. State-funded bail within community-based support. And one of the benefits of ATDs is that it actually relieves the burden on the state. So there was a report recently, I'm sure a lot of you would have seen it, on the amount of money that the state spends on immigration detention and keeping people in detention, deporting people. So some of the things that would be a benefit, for example, you get a lot of people who are willing to voluntarily return to their countries. But you find that, so a lot of the things that we find is that a person would be in the country legally and then, or irregularly, and then they would go back or decide to go back to their country of origin. We have many cases where people who would come into South Africa. I'll just give one particular case study. They were asylum seekers from Egypt who are members of the LGBTQI community who came into South Africa to seek asylum. But because of the complicated system of the asylum system in South Africa, they were unable to get that protection, and therefore they decided they don't feel safe in South Africa, and so they were going to leave. They have their travel documents, and when they were at the airport to leave the country to seek asylum somewhere else, they were arrested. And they were arrested and detained and kept in South Africa. It's like, why are you keeping these people when they want to voluntarily leave? So one of the considerations that we suggest to legislation is to allow voluntary return of people. Okay, so the next thing that I really want us to talk about, and I think is very important, is collaboration. So collaboration is essential for effective representation of these marginalized people. I want us to discuss so we're gonna go into the question and answer segment of my session. And I want us to discuss the benefits of collaboration, particularly with the organizations that are here today. So, for example, as I mentioned, Legal Aid South Africa provides criminal representation in the magistrates' courts and in higher courts as well. So one of the things that we have struggled with, because we run a hotline, we run a immigration detention hotline where we receive an influx of cases of people being detained. One of the challenges that we face is that we don't have a line to refer these matters. We do know that Legal Aid South Africa is present in courts every single day, but we think that it would be beneficial to be able to refer the matters, especially because we have a lot of information. When a matter is referred to us through our hotline, we gather a lot of information, and it would be beneficial to actually refer those matters and to aid those people. I'll give an example that has happened a few times where, because I come from legal aid, I do know a lot of people in legal aid, I am able to directly refer matters. But what usually happens is that when matters are referred, they usually get lost. So I'll refer a matter to the Johannesburg local office, for example, and people are very responsive, then they're willing to assist. But what would happen is that the person would then appear in a different court than to the person that I've referred the matter to. And because I can attest to the fact that, this particular field of law, this refugee law particularly, is very niche, what would happen is that those matters would fall within the cracks. Also, we do know that as is present today, there are a lot of private legal practitioners who are interested in actually taking on some of these matters. It would be great to have like a network or context of those legal practitioners who we can actually refer those matters to in the instances where we are unable to actually take them on. And one of the things that we wanted to discuss is how would that best be effective, especially also with our partner organizations such as LRC, where they particularly deal with niche matters, which we may not be in the best position to actually take on. It would be great to establish particular maybe MOUs with these organizations to actually have an effective referral system when it comes to immigration detention matters. Okay, so now I will open up the floor to questions. If anybody has any questions, yes.
Okay, firstly, thank you for, I think, what was a very insightful presentation, very detailed as well, and just well prepared. Thank you for that. I just have a question with regards to the end bit of your presentation where you spoke about alternatives to detention. And I'm just wondering, realistically speaking, what does that look like in a third world country? So I know you quote examples such as Colombia and Zambia, but I think it's worth noting that these are countries that have refugee settlements and refugee camps, which is what, you know, we don't have in South Africa. And we see more urban refugees who are allowed to integrate into society and whatnot. So I'm just wondering, just out of interest's sake, is the path of refugee settlements something we should start to consider in South Africa? Given that, yeah, it just seems to work better in countries who followed that model. I know there's philosophical reasoning for why South Africa chose not to go that route, but is that something worth considering at this point?
All right, thank you very much for the question. So I think I'm particularly referring to matters where people are being charged with an offense, where alternatives to detention should be considered. So even in the countries that do have camps, the consideration is whether people should be kept in prison, particularly, pending the consideration of the regularization of the person in the country. But when it comes to the question of encampments, my personal opinion, and I know that is the opinion of lawyers for human rights, is vehemently against encampment, because it further legitimizes, oh wow, English. Yes, the criminalization of migration, which our argument is that migration is a very natural phenomenon and should not be criminalized. And yes, in South Africa is a third world country, more progressive and a bit more, well off than countries like Zambia. But even in South Africa, even in countries like Colombia, what they have found is that the research shows that it is a myth that inherently crime in South Africa is because of the presence of migrants. Even in Colombia, when there was an influx of Venezuelans, when they did the research, they did not find that there was inherently more crime because of the presence of migrants. So I would say no to encampment on that basis, on scientific research that shows that it does not, in fact, the presence of migrants can be beneficial, and that it is not inherently bad or does not create chaos inherently. I mean, that is debatable in the current climax, especially internationally, when we see countries like America regressing and Britain regressing on migrant rights. But when it comes to actual studies, research, the claim that the presence of migrants in a country are inherently bad has not been substantiated. Yes.
Thank you. I think mine is more an add-on to the presentation rather than a question. As I indicated, I'm from the National Preventive Mechanism. So we usually conduct visits to places of detention, such as your immigration detention centers, police station, correctional centers, etc. So a trend that we picked up is that besides Lindela, the Immigration Act now allows for certain police stations in provinces to also be used as detention facilities for undocumented foreign nationals or immigrants. So you can imagine that, unlike Lindela, the infrastructure of a police station is not suited for long stays. So you find that also magistrates are now more punitive, wherein every case of an undocumented national or immigrant is more criminally charged. So you find that they're now detained in a correctional center for 6 to 3 months, and then from there they go back to a police station awaiting either deportation or transfer to Lindela. So in this process, a person can be detained in a police station for months on end. We have found instances where people have been sitting in a correctional center for 6 months, a police station for 6 months, only to then be transferred to Lindela to still sit there for another 6 months, a year, waiting deportation. So in that, I think in the term of collaboration, we need to also bring in these respective departments, such as your Department of Health, Department of Justice, and even the detaining authorities that are responsible for these places of detention or authority. So I think a more holistic approach will assist in that, because as I indicated, also having discussions with DOJ would assist with them following a more progressive approach instead of punitive. And I would tend to agree with the ATD, because it will also assist with alleviating pressure on these places. Because now you find that police stations and correction centers are now overcrowded because of the detention of immigrants or undocumented nationals. Thank you.
Okay, so just responding to the comments of the alternatives to detention. I'm not sure whether or not the LHR or the South African Human Rights Commission is perhaps able to drive this, but what I am going to submit is that there definitely needs to be, I think, sensitivity workshops, if that is the correct way of putting it, with regards to the judiciary, and I'm talking about magistrates in the lower courts who most often deal with this, and then also the South African police services, because what we find is a resistance to, as you've said, the idea that migration is actually quite natural, and it shouldn't be regarded punitively, and we are all citizens of the world, and we all have a right to be here. I think the thinking is very compartmentalized, and so when we have SAPS officials, for example, dealing with people who don't have their permit on them because it's an important document, and they're scared if they walk in Belleville they might get robbed of their bag, instead of that simple act of compassion, gosh, it's basic human, understanding of taking that person to their home address to go and collect the document, they are detained. And then the magistrates as well, you've listed factors previously which are all contained within our legislation. It's in the Criminal Procedure Act. Look at family and emotional ties. Look at why is the person here. So we've got the legislation, but the attitudes are still very, I don't even know how to phrase it. It's incredibly frustrating when we go up against prosecutors, so the NPA as well, I suppose I should group into this bracket, where the attitude is, well, hostile. Yes, hostile, there we go. So I think those sensitivity workshops really is important. We have, however, seen a move for the better. I think in terms of 10 years ago, when we would bring applications for releases of clients, and then the mere fact that they're undocumented or their permit has expired is a grounds for denying their release from detention. We've moved away from that, and I must say that we've had a greater success rates in securing the release of these clients, but we still have those sort of systematic issues every single day, where we've got to battle with the police to do something as simple as going to somebody's home to go and collect a document. So yeah, I don't know who's able to maybe push that these sorts of workshops happen, because I feel that we should be having members of the judiciary, of the NPA, of SAPS attending these workshops. It's very important.
I think it's very articulately made by others, but it seems to me that, thanks so much, you know, lawyers are bringing cases into the courts, challenging legislative provisions quite successfully, and LHR has absolutely been at the forefront of that. And I think the question for me is, the point that you raised now is, for example, despite the successes in the Section 34 challenges, that systematically you're still finding challenges on the ground, which means either there's intentional flouting of the law, which I think is a real concern and might be still an issue, and that's what I wanted to ask you about, versus it's simply a lack of knowledge on the part of the implementing officers, and it's probably a combination. And the question really is, how is that addressed? And I think the suggestions around, you know, sensitivity training are really important. So in sessions like this, it shouldn't just be the lawyers, but absolutely the implementing officials. And yeah, I don't know to what extent the Human Rights Commission could be playing that role. But I think also investigations potentially by the Human Rights Commission into these kinds of abuses really would also be quite important in terms of shedding light on the abuses, because they seem to be happening, you know, behind the scenes, and nobody really knows what they're doing. Or alternatively, if litigation is still going to be necessary, then I guess we're moving towards litigating against systemic practices and abuses, and not just legislative provisions. But that would absolutely be the measure of last resort, I guess. Thanks.
Thanks, Nyeleti. Good morning, everyone. Thanks for your comprehensive presentation. I think just to ask one question, particularly pertaining to children, I think you've mentioned the issue regarding the fact that you will assist a child who's been unlawfully detained and place them at a place of safety. So in terms of approaching the children's court and so forth, if so is possible, are there any sort of like placement order that are granted in that regard? And what has been the response from social development when it comes to the issue of repatriation and deportation of children in that regard?
All right, thank you all so much for the questions, the comments, the suggestions. I'm really grateful that we have such caliber of people in the room, and it is particularly important for us to collaborate. I think the intention of having legal practitioners first is for us to strategize together, particularly with the people in the room who directly deal with these vulnerable people. And I do agree that there is a need to have other stakeholders, particularly the police, the judiciary, in these kind of discussions. And we have had some engagement with the judiciary in the region, not particularly in South Africa. It's very difficult us to have that access. And that's why it's very important to have partnerships with people in the room to be able to be persuasive when we try and approach the judiciary, for example, to say we want to talk about, because they're not open to be trained by attorneys when they are the judiciary. So it's very difficult to approach them in that sense, particularly government officials. You'll be told, no, you have to send this to this department, you need to send it to that, and you never hear back. Particularly with BMA, we've made efforts to have them in the room, Department of Home Affairs, but it is quite a difficult task to do on our own, and that's why we want to have this collaboration. So it would be of more force to actually approach those stakeholders as a collective, as opposed to just one organization trying to approach them. So thank you very much for those for those contributions, and I am hoping that this will not be the last. One of the things that I don't like about these kind of workshops is that we talk, and then it ends here. I'm really hoping that we do establish this referral network or this collaboration where we can act in unison and actually tackle some of these issues. It is litigation should definitely be a measure of last resort. I'm particularly a fan of a multidisciplinary approach. Definitely, there is a need to tackle these matters in other ways, not just taking departments to court or challenging legislation. To answer your question, Fortunate, I think you would be in a better position to actually elaborate on that position, because we receive very few matters of children at LHR. Particularly when it comes to detention, we have not had the opportunity to approach the Children's Court. That is definitely something that we'll be open to doing. I have been attending a lot of these steering committee workshops on unaccompanied and separated children, migrant children, and what I have seen to be the pervasive position is that DSD is very much focused on repatriating the children, without actually considering if it would be in the best interest of the child to actually repatriate that child. They have great relationships with the countries of origin, and they make great efforts to repatriate these children, without considering whether it would actually be in the best interest of justice. And what we try and do is we try and collaborate and sensitize the Department of Social Development when it comes to that, but it's a very tender relationship with them, and we definitely would like to work with the Center for Child Law in approaching that. Particularly, there's an upcoming workshop where they want to train, for example, what they call, parole, the social workers who deal with children in the courts, what are they called? Probation officers, yes. So there's a training of probation officers that is a great opportunity to delve with these issues on, and would like to speak and collaborate and be present in those kind of workshops to sensitize the Department of Social Development. All right, thank you all so much. I'll hand over back to Tanya.
Thank you all once again. We will now have a 10-minute break. Please be back promptly at 10:48. Thank you. Okay. Welcome back, everyone. So our next session explores South Africa's asylum system. This is led by Khomotso. Please welcome Khomotso.
Good morning, everyone. As mentioned, my name is Khomotso Malapo, a candidate attorney under the Refugee and Migrant Rights Program at Lawyers for Human Rights in Pretoria. And it's an honor to stand before such esteemed colleagues to discuss the important issue that impacts thousands of vulnerable individuals in our country. And just a disclaimer, I tend to be a bit nervous in the presence of experienced legal minds, so please forgive me if you experience that throughout the presentation, sorry. So before I begin, I would like to ask a question. It's not a question that you have to answer, but will just help in guiding us and trying to help us to understand the whole asylum system and why is it that people flee and why is it that they end up fleeing to South Africa. So it's just a scenario in a form of a question. So imagine you're being forced to leave your home overnight, and now you have to leave everything that you've ever known, your family, your career, and your sense of identity. And now imagine you arrive in a new country where you're desperate for your safety, only to find out that the very same system that was meant to protect you is now stacked against you. how would you feel and what would you then do as an individual? So the question that I posed is just to assist us in understanding the whole asylum system as a whole, and why is it that people choose to flee to South Africa. So this is not a theoretical question, but this is like a daily reality of more than 190,000 asylum seekers that are currently in South Africa. And these individuals obviously fled from their country because of war, persecution, and any other unimaginable hardships. And then when they come to South Africa, they are met with delays, rejections, and like increasingly restrictive systems. So our role as legal practitioners and human rights defenders is then to ask, are we upholding the law and protecting refugees? Or have we built a system that is then designed to exclude them? So if I may begin, today I want us to have like an open and practical discussion about the legal framework, the application process as a whole, and the challenges that the asylum seekers face in the application process, and the solutions that we can work towards. I think you can move to the next slide. So I'm just going to touch on a bit about the legal framework and principles. So it's safe to say that in theory, South Africa has like a well-established legal framework for refugee protection. And this is seen in the Refugee Act, as it defines a refugee as any person who has fled their country of origin due to a well-founded fear of persecution based on religion, nationality, political opinion, or being a member of any particular social group. So the definition also includes individuals that fled war, violence, and mass human rights violations. So this definition under Section 3 of the Refugees Act then aligns with the 1951 UN Refugee Convention and its 1967 protocol, which South Africa is then a signatory to. So the key protection in both international and domestic refugee law is then the principle of non-refoulement. So this principle simply says that no asylum seeker should be sent back to a country where they face persecution, torture, or death. However, I think in practice we have seen that this principle is often violated, as Nyeleti has mentioned, and she touched on the case of Ashibo versus the Minister of Home Affairs, whereby the government failed to uphold this principle when an Ethiopian asylum seeker was nearly deported, despite the clear evidence of being in danger. So this person has a clear claim and they needed to apply for asylum, but they were not really given that opportunity to state their claim. Instead, they were then detained and they were almost deported because they did not have the opportunity to then lodge their claim with the Department of Home Affairs. Based on the case of Ashibo, we have to ask ourselves, how often does this happen? Say in 2023, we've had over 1,500 asylum seekers who were deported. This is just a number that I came up with. It's just something that I'm not sure of the stats, but I'm just assuming that say we have 1,500 asylum seekers that were deported in 2023 alone. Some were even not afforded proper hearings. They were not even given the chance to approach the RROs. Some did not even have the chance to lodge their claims as they should. So you have to ask yourselves, how many of those were sent back to war zones, persecution, or death? And was it even considered that these people fled to South Africa because they faced those things back home and it's not possible for them to go back? So now I think another issue that we have in the system again is the Refugee Appeals Authority Backlog Project. So this initiative was then introduced to clear like thousands of asylum applications that were stuck. So despite the effort, or despite the years of effort, the backlog still remains overwhelming. The Refugee Appeals Authority and the Standing Committee are meant to oversee the appeals and the status determinations. But instead, these two bodies are then severely understaffed and underfunded, which means that many cases can go unreviewed for like 10 to 15 years, and this keeps applicants in like legal uncertainty because they can't even get documents. If they don't have documents, they won't have their stay is not legalized in South Africa. They can't work, they can't access education. Okay, theoretically it says that they can, but in practice it's not really, they can't access education. You have to now then force yourself to advocate every now and then for something that's like there on paper to say that undocumented learners can then get access to education. But when you have to get that access to education, then it becomes a problem. So I'm just going to touch again on the application process and the challenges that come with that part of the asylum system, So according to me, I think the asylum system is meant to ensure that those in need of protection receive it. But however, in reality, it has become like an administrative maze. It's something that's not achievable. It pushes people into like a sense of undocumented status. And so it pushes them to being in a status of being undocumented, which then leaves them to be vulnerable to issues of detention, deportation, or even worse, physical attacks, and that even come from like our body of state, or the organs, SEBS. We've had issues in practice where there's a case where a client would come and they tell you that I was stopped along the way and they needed to see my documents. I tried to supply them with the reference number that I got from Home Affairs to show that I'm in the process to apply for asylum. But instead of them trying to understand that this is a process, it doesn't happen overnight, they then tend to try to solicit money out of them. And if you don't have money, then unfortunately you become a victim in that instance, and you might end up being physically attacked by those particular people that are then supposed to protect you. So I'm just going to go, so I'm just going to give like an overview of the stages in the application process, and yeah, I think the challenges as well as the reasons that many applications are rejected on. So the first step is for an applicant to then, the first step is for an applicant to approach the RROs that are closer to them and then try to register. So this is where an asylum seeker must apply for what we call the Section 22 permit, which allows them to remain in the country while their claim is being processed. However, a lot of the RROs are overcrowded, they are disorganized, and they tend to be a bit inefficient. I think the biggest culprit of them being the Tshwane RRO, because so the system is always down, the system is offline, we don't have people that came in today, can you please come back next week? And you'd find that the applicant is coming all the way from Bloemfontein, and the closest RRO to them is the one in Pretoria. Now they come all the way from Bloemfontein to apply on the day, thinking that they would succeed and then go back and wait for the process to be, for the whole application to be processed. But instead, when they get there, they are notified that the system is offline, or we can't proceed with working today because we are understaffed and such, which means that this will lead to the applicants then sleeping and camping outside, and which in a way would end up resulting in the physical attacks as mentioned before. So the second step would then be to have if you proceed with the registration, you would have to have an asylum interview with the refugee status determination officer. So this is the part where the applicant explained the reasons for fleeing to South Africa and for seeking asylum. But how can they do this if we don't have interpreters available? So this then flags out the issue of language barrier. We have a lot of people that come from DRC, we have a lot of people that come from Burundi, Kenya, and then they are not really that good in English. They can say that, yes, I can hear, but having to articulate what I want to say is something else. And then this would then lead to like a misinformation between the RSDO and the applicant, in that they would end up assuming, or they would even ask questions that are not even relevant to the application process. Normally, they would listen to your story, but there comes a time where they mention that, would you then work in South Africa? And if you answer that the question and say yes, if the opportunity arises for me to work, then I would take it. Then your claim is based on economic stability. It means that you came to South Africa to work. The previous claim that you mentioned, that you fled for political reasons, is then not considered. So they assume that you came to South Africa to work. And another issue is when they get the RSDO decisions, when they are rejected, we note that a lot of information in those decisions is a copy and paste information. So you'd find that there are two applicants from the same country with different claims, but when you go into the decision or reasons for decisions, they are often copy and paste. They don't align with the claim of the applicant. Even the country of origin analysis, it doesn't align with what the applicant is saying. And then they go on to reject that person based on the country of origin on an analysis, so these are some of the issues that we flag out during the consultations that we have with clients on a normal basis. I think another issue would be that during the interviews, they tend to they don't have like a privacy kind of interview. So they're just interviewed on the corridors where they ask, why did you come to South Africa? You tell them, and then the part where they ask about employment, and then you say that it takes less than 5 minutes. They don't even understand the claim. They don't even bother to get more insight as to why you came to South Africa. Even worse, when you don't have a passport, just know that the chances of you being interviewed are very slim, because you'd be told that you're in the country illegally. How do you expect us to assist you? Do you even have a passport to show that you passed through the border? But the problem is that these people, when they flee, they don't even get the chance to take all the documents that are necessary. And even when they apply, they are told that please give us evidence to show that this happened to you back in your country. But if I was injured, or if there were attempted murders, and how am I going to prove that point to say that, yes, this is what happened, I was almost murdered in my country due to these reasons? I won't have like documented evidence of that. So those are the things that cause delays in processing the applications. As soon as the interview is done, then the next step would be having to make a decision. So it's either the RSDO grants asylum or rejects the claim. But however, what we have noted is that the rejection rates are extremely high, and when you take a look at them, the decisions lack proper reasoning, as I've mentioned. So it's either copy and paste of the country of origin analysis, or it's just a claim that was not even what was said by the applicant. So when they are given a chance to then appeal their applications, that's when they get to write whatever that has happened to them back home. And then you can know there's a huge difference between what is written in the claim by the RSDO officer and what is written by the applicant. So claims that are rejected, they can either go to the standing committee or they go to the Refugees Appeals Authority. But due to the massive backlogs that I have mentioned, these appeals take years, they take longer to be processed, and then this leaves the applicants in a state of uncertainty. So it takes about it may take about 10 years for someone to get their decision. So you have someone who came in South Africa back in 2009, they got a chance to appeal in 2013. So from 2013, they only get the decision in 2023. So you can imagine what has been happening in that person's life for the past 10 years. And now, the decision says that unfortunately your claim has been rejected, and then you're given 14 days to leave the country. And now you have to figure, where am I going to go? And when you look at the report or the country of origin analysis, whatever that you fled from is still happening back home. There's no way you can go back there. And even being resettled to a third country in most instances is not really, it's not practical, if I'm being honest. Now you find that people are saying that I want to go to USA. I'd rather go to USA, I'd rather go to Canada, I'd rather go to, but looking at the state of things right now, there's no way you can go to USA and there's no way you can go back home. Now you're stuck in South Africa, you can't appeal, and now you have to, you have to explore other means of trying to get yourself documented again. And if your appeal is rejected, the only resort that you have to that is through judicial review, which are costly. And our clients are vulnerable people. There's no way they can afford to pay that amount for a judicial review. So I think I'll just go more into detail on the reasons why applications are rejected. So the first reason that we normally note that is very popular in the law clinic as manifestly unfounded claims. So the claims are the cases are dismissed outright without proper consideration. So when an applicant comes and they share their claim with the RSDO, if they don't have evidence to prove that or if the RSDO believes that the claim is not sufficient for him to grant refugee status, he then continues or proceeds to reject the application as manifestly unfounded. And one which is common, but at least there's a turnover from, is the unfounded claims. So these applications are rejected because an applicant failed to prove that the persecution indeed happened, even when the applicant has evidence to prove that. So they are rejected just to say that, but this is no longer happening back home. You can still go back right now because this has happened, like this happened back in 2013. So you can go back home. They don't even consider the evidence that the applicant has on paper. So another reason has to be abusive claims, but we hardly get any of these. So this is where the applicant is suspected of using the system for economic gain despite having like a legitimate claim. So they might have a claim which is proper, and it's one of the claims that are mentioned in Section 3 of the Refugees Act. But because they mentioned the issue of then getting employment in South Africa, they assumed to come here for economic stability. That's why the applications are then rejected as abusive. So the last reason, which is also a bit common reason, has to be the fraudulent claims. So applications in this instance are rejected due to the inconsistencies in the applicant stories. So as I've mentioned, this is often caused by translation errors. So DHA has their own set of translators, but according to what the clients say is that, so I'm just relying on what we hear during consultations. When you ask that, were you afforded an interpreter because you mentioned that you couldn't speak English? And then they say that, yes, I was afforded an interpreter via a phone call. But what I was saying is not what the interpreter was saying to the RSDO. So this happens in instances where the client can understand a bit of English, but they can't really like understand everything. But they can hear that whatever I'm telling the interpreter is not what the interpreter is telling the RSDO. But unfortunately, there's nothing you can do in that instance because you're just a victim yourself. So they proceed with the interview and then proceed to give you your rejection, and then they are done with you. So additionally, the Standing Committee and the Refugee Appeals Authority are the bodies that uphold the most rejections as compared to the RSDOs. And this leaves the applicants with no choice but to pursue what we call the costly judicial review. And this is a process that not many can afford, given that they can't even work because they don't have documents at that moment. So, as I've noted the challenges, I think it's also a good thing that I try to come up with the strategies for advocacy and reform with regards to the challenges that I've just noted. So given the failures, the question we must ask ourselves is then, how do we then fight back as legal practitioners? How do we make the system work for those that it was designed to protect? And I just tried to come up with at least 4 strategies that I believe that we can try to apply to these instances. So we can try to build strong claims, strong asylum claims, and we can do this by ensuring that asylum seekers receive proper legal assistance. Say they have a hearing before the Refugees Appeals Authority. We can try as much as we can to make ourselves available to properly guide them throughout the process, and we can also try to avail ourselves during the hearings to at least see if procedure is being followed, and if not, we can then interject to say that this is not what you're supposed to do as the interviewer. This is not how the process is supposed to be done. And the second strategy would then be to ensure procedural fairness. So we can try to advocate for like well-trained decision makers, and we can try to advocate for fair hearings. So we can try to raise the issue of RSDOs that are acting outside their scope of work. We can try to advocate for RSDOs that just dismiss claims because they don't suit them. We can try to advocate for RSDOs that can actually do the work that they are designed to do. And then the third strategy would be building a collaboration with other civil society organizations. So groups like LHR provide critical legal support, and they try all they can to challenge unfair policies. So I think it's only fair that we can try to build collaborations with organizations like Pro Bono, the Human Rights Commission, and any other organizations that can deal with these issues in this instance. So the last strategy would be strategic litigation, but this would then be the measure of last resort in this instance. We can try to do all those 3 as mentioned, and then if they fail, we can then go into strategic litigation. So instead of handling one case at a time, how about we then focus on impact litigation? We can try to challenge the laws and policies in court, and then we know that when we get the judgment, we can try to use that judgment for creating a systemic change. And I'm not really limited to these 4. I've noted other 3 that I think they might also apply in this instance. So we can try to monitor government practices. So we have stakeholders meetings with the magistrate court in Pretoria bi-monthly, but the problem that we have is that when we get to invite Home Affairs to be there, they don't actually honor the invite. We are being told that immigration officers are busy, and while the issues that we are discussing, they actually need them to be present, so we can try to monitor their practices and at least hold them accountable for the mess that's going on at the moment. And then the second one would be having to engage with administrative bodies. So we can try to push for reforms in the Refugee Appeals Authority and the Standing Committee, as they are the ones that deal directly with these issues of asylum seekers. And the last strategy would be having to deal with the myth busting. So how about we try to counter false narratives that asylum seekers are in South Africa because of because they are economic migrants? How about we try to move away from actually trying to criminalize everything that they do, when we don't even have stats to prove that they are the ones that are at the forefront of our criminal activities. So I think I'm about to conclude, but before I conclude, I would like to focus on the implications and recommendations in this regard. So the failures of South Africa's asylum system don't just harm asylum seekers. So they undermine the very same principles of justice and human rights that our legal framework is supposed to uphold. So when the system doesn't work, obviously people don't just disappear. Instead, they are then forced into a status of being undocumented, which has devastating consequences, as I've mentioned. You can't work, you can't find a place to stay, you can't even find a simple shelter because shelters are not willing to accommodate people with no documents. So without valid asylum seeker permits, they can't legally work, as I've mentioned. You can't even have a simple bank account, and they struggle to access health care. They've been turned away a couple of times at hospitals to say that you don't have documents. How are we then expected to assist someone like you who doesn't have documents? And many are forced to live like on the margin of society, constantly fearing arrest, deportation, or even physical attacks, as I've mentioned before. So we can try to consider this. What happens when an asylum seeker who has been waiting for 5 to 10 years for their appeal, they cannot legally work, as I've mentioned, so they tend to take employments that they will end up being underpaid, or they will end up being in like exploitative jobs that don't really suit their needs at the moment, but because they need to survive, that's the only measure that they can resort to. So if they are lucky, yes, they can get those work and be underpaid and exploitative, but that's not what we are willing to settle for. And others, they might end up being homeless, and they turn to informal economies just to survive. And the children of asylum seekers despite being legally entitled to education, they are turned away from schools because they lack the right documents, even though they have circulars that state that undocumented learners can gain access to education regardless of the documentation status, obviously. But when it comes into practice, that's where you have to fight with the Department of Basic Education. You have to fight with the district to say that, but this is what you've mentioned. And now you get clients in a frustrated state saying that my child can't go to school because I've been told that the birth certificate that I have from South Africa doesn't have the 13-digit number, meaning that this child cannot be registered. And now you tell them that this is the circular, this is what it says. Even if they go with the circular to that particular school, they are not being assisted. And yet they did say that the birth certificate is accepted as proof of identification. So those are some of the issues that we faced and some of the issues that we flagged out in the law clinics. And we try as much as we can to engage in them, but in most cases we are not really successful because we tend to end up fighting with the schools when it's not necessary to fight, because we try to convince them that this is what you should do, and can you please try to get this child enrolled so that they can continue with their studies. And if there's a need for the mother to try and get the child documented, they can do that in the process of the child being enrolled in the schools. And if I'm being honest, it does not really succeed in most cases. So you'd find that the parent has to wait for next year so that they can try to enroll the child again. And even if they try to apply for what we call a family joinder, having to join the child under the parent's file, that process, again, it's a long process. You take 3 to 6 months just waiting for a mere letter from Home Affairs inviting you for an interview, just to come so that you can have the opportunity to join the child to the file. And in the meantime, when you're waiting, you try to explain that I'm waiting for Home Affairs. This is the letter to show that our appointment is on this day. They won't assist you even if you have that letter. So those are the issues that we flagged out, and we are trying to find strategies from other organizations to see how can we go about this, because we've tried the strategies that we had at the moment. Sometimes they work, sometimes they don't. So how about we find something that's like what's the word, a reliable system that we can, yes, sorry. But yeah, we can try to find something that we can rely on, that we know that if we try this, this is definitely going to work. Because the issue of having to go back and forth, having to enroll a child into a mere school is not something that we should be going through. So as I conclude, so we've noted violence again. We've noted like physical attacks that have happened in 2023 alone, whereby at least 15 asylum seekers were physically attacked, with some cases involving mob targeting foreign nationals, the issue of spaza shops. So these attacks are often fueled by misinformation. So the belief that the asylum seekers are taking jobs or committing crimes is what ends up leading us into that kind of mess. So if we are being clear, I think the real issue in this instance is the failing asylum system that pushes people into undocumented status, which then makes them more vulnerable. And I think on the practical solutions part, the question we must ask ourselves is, what must change? Now we know the problem. How about we talk about the solutions or the practical steps that we can use to make a difference? Say if we were to suggest that they fix the backlog and speed up the asylum processing, would this solution be implemented in practice? The Department of Home Affairs must just try and see if they can increase staffing at the refugee reception offices, and they must try to actually use technology to track applications transparently. Then we don't have to request file contents from them every now and then when we have an instance where a client need to see what's happening in their asylum application. If there's a system that's designed for that, it's easier to access the client's file on the system. But obviously this would then be the client's confidential information, meaning that they are the only ones who can access the information. But because they come to us for assistance, we can then try to have like an insight into the information as well. So regular status updates must be provided so that asylum seekers can know where they stand. The issue of going back and forth to the RROs just to ask how far is my application, and then you're being told, please come back next week. Next week we'll have a response for you. When you go back next week, they tell you that please come back the other week. The person who was interviewing you is not in the office. So that's not going to work. So it's best if they have regular status updates. I mean, they have contact details of the applicants. It wouldn't hurt for them to just send a simple message, as they can send an email to say you're invited to the RRO, just to send a simple message to say that your application is then being reviewed. The next step is for you to be interviewed. Those are the simple things that I believe that can loosen up the asylum system. So the second one would be trying to ensure fair and consistent decision making. The RSDOs must receive proper training to fairly assess the claims. They need like proper training, because the ones that are there at the moment, it's just a matter of trying to resolve the backlog. They don't then look into the claims as they are supposed to. They just dismiss the case so that they can see the next person, which is not working in the favor of our asylum seekers. So we need a clear appeals process with reasonable timelines. The issue of having to wait for 5 to 10 years just for a person to know that they are rejected is not going to work. So reasonable timelines must be enforced. So no more waiting for a decade to get a decision. So I think also improving access to legal aid. I feel like civil society organizations must then try to, they must be funded, they must get like proper funding to provide free assistance to asylum seekers. And in this instance, I feel like private legal practitioners as well should be encouraged to offer pro bono services where possible for appeals and urgent cases that involve asylum seekers. And then we can just try to challenge discrimination discrimination and xenophobia. We can try this by having community education programs that should counter myths about asylum seekers, and then these programs can then highlight their contributions rather than vilifying them into something that they are not. So we can also try to have the law enforcement trained on how to protect asylum seekers from xenophobic attacks rather than being at the forefront of those that attack them during these attacks, because they were meant to protect them, but instead they are in solidarity with the community when these kind of events occur. So I think I'll pause here. But the last question that I would like to pose as well is, do we want an asylum system that protects human rights or one that pushes people into further suffering? Right now, South Africa is currently at crossroads, and if we allow the system to remain broken, we are then complicit in the suffering of thousands. But if we try to act now, and if we try to demand reforms and challenge unjust laws and provide legal support where it is needed the most, then we become a part of the change and the solution. So I leave you with this question: are you ready to do what is necessary to fix the system, or we will continue to look away? Thank you, and I think I can open for discussions. I'm not only open to questions, I'm open to solutions and strategies as well. Thank you.
Thank you very much. My name is Shafiq Amirmia. I'm the National Director for Pro Bono, and my team is here with me. And I want to say that I appreciate both the inputs that were made this morning, very informative. We at Pro Bono see a rise in a number of refugee matters that come to us, be it from an undocumented child who needs to get into a school, to a point where we get people who are applying for asylum and getting rejected as well. So I think what I want to say to this house here is that we're sitting in a very powerful room here, because the South African Human Rights Commission is just not an NGO. It's a constitutional body that has leveraging constitutional powers. And I think if we rally around the powers and functions of the South African Human Rights Commission, and I'm not advocating, I'm not the ambassador, I was a former Human Rights Commissioner, that's how I know these things, is basically to use this particular platform to access justice to the highest level. The issue that we're talking about the most vulnerable people in society that have come with only clothes on their back into our countries. And what they see out here, and I give the example after going through my refugee clinic. If you think, you call New York the red apple, you can see the comparison with Home Affairs at Marabastad. You can call it the rotten apple, because that's exactly what it is. And exactly what you said, ma'am, is that come tomorrow, and come tomorrow. You are playing with the lives of the poor and the vulnerable, who at least have a right to dignity, which is one of the fundamental principles of our Constitution. I'm not here to give a lecture here, but I just want to basically say that today's, you asked the right question, ma'am, in the end, the way forward. And I think the way forward is, we have an organization sitting here called the Empire Partner Foundation, who basically digitalized our case management system. And in the last financial year, I just want to give this as an example, we had 5,037 cases across the board, and all of them are basically captured in our data system. EPF is sitting in the room here, and obviously we can have a discussion with them afterwards as we form a kind of a collective committee out here, basically to offer that kind of service to the house here, because LHR pioneered a lot of good work in the space, but obviously if we do not work as a collective, our work goes unfazed, and everybody sits with the same problem. We have basically reached out to all the NGOs, to all the legal practitioners through the architectural framework on access to justice that Pro Bono has, to help us to kind of find a solution to help the poor and the vulnerable live in dignity, equality, and freedom like everybody else itself. And I think what I want to see that's coming out of this exercise is, like you mentioned, judicial review is extremely, extremely expensive. Now, for a person who has got no money to come from Pretoria to Johannesburg, just to come and access justice, even at the Human Rights Commission, you expect that person to take a matter to the Constitutional Court. Let's be realistic, it's never going to happen. And then we come back again here and we talk about the same old thing. So what I'm saying is, and I also know, because we've been involved, because of our involvement as pro bono in the space, in the short time that we have now basically, delved into the space, we have also found that there's 120,000 cases backlog in Home Affairs. Now, picture yourself as a refugee where your assignment papers are rejected. You're going to be waiting in 120,000 plus one and over before your matter can be this thing there. So if you're talking about an asylum paper that's going to give you a few days within which to go and review it, imagine you're going to spend like 300 years before you're going to get access to remedies in this country. I'm saying is, people, I'm glad that the Human Rights Commission could convene this. I'm grateful to COMSA and LHR and everybody else that's here, including the good work that CDH has done. It's for us to now basically hold hands and say, what we need to do is we need to set up a kind of a lobby group that must insist, and the Human Rights Commission has got the power of subpoena, to insist that we meet with the Portfolio Committee of Justice at least 4 times a year. And this committee will then basically tabulate all its kind of challenges and say to the Portfolio Committee, what is it that you're going to do? It can then take matters to the Constitutional Court if need be. You can take the matters, to policy and amend legislation to be human rights centric and friendly as well. So thank you for the platform, thank you for the opportunity, and keep up the great work. We are all in it together. We will make it happen. I thank you.
Thanks. Thank you, Speaker. I just have one question, maybe two. Can a person who has been granted asylum in South Africa apply for asylum in another country? I'm asking this question because some time ago in our office, a lady from Ethiopia who have been granted asylum together with her husband by South African government. And the husband was then killed in South Africa. And then she came to us wanting to apply for asylum to Australia. So can that happen? And number two, can an asylum be cancelled? And if so, under what circumstances can be cancelled? Thank you.
So if I'm understanding you, you're saying that can a person who applied for asylum in South Africa then apply for asylum in another country?
Asylum is already been granted, but then the situation changes. It says that the husband get killed.
Okay.
She does no longer feel safe in South Africa. She wants to go to another.
All right. I think this then raises the issue of what we call a resettlement. This is asking to be resettled to a third country. So yes, it does apply to someone who has a valid asylum permit in South Africa. So I think it is possible for it to be, it is possible for the person to be resettled to a third country. When it's cancelled, that's when we say the applicant has been finally rejected. So when they are finally rejected, that's when they come to a conclusion that your asylum has been cancelled if you then don't pursue judicial review. So if the 180 days to pursue judicial review lapses, and yeah, I think so, then they can then proceed to cancel your asylum. Or if you don't, in any instance, try to renew for, I think, I forgot the period, and then they then proceed to say that you abandoned your asylum process, and then they can proceed to cancel it. Sorry. Thank you so much for the platform.
Thank you. That was a very insightful presentation. Okay, up next we have statelessness, where we will be discussing how we can protect vulnerable populations. Palesa Moloisane will be leading us through this presentation. Welcome, Palesa.
Good morning, everyone. Please forgive me. I decided to leave my glasses in my car, so if I stumble over my own notes, it's just because I can't read. As Tanya introduced me, my name is Balasama Loesane. I am an attorney in the statelessness unit at Lawyers for Human Rights, and super grateful for such a positive space that we've really fostered here and coming up with solutions towards some of the issues that we're facing and continue to face. So what I'll be touching on today is just an overview in looking at issues of statelessness and nationality within South Africa, and particularly on the protection of this vulnerable group. Statelessness is very interlinked to some of the other presentations that will be happening today, such as birth registration and citizenship in South Africa. So apologies to my colleagues that will be presenting on that if I overstep and overlap on them. I think to start with, we can go to the next slide. I just want to start with, one of my really favorite quotes from the Concord that was handed down, because I think it really looks into the heart of what citizenship and identity means in Chususe versus Director General of the Department of Home Affairs. Because the court really recognized the constitutional importance of citizenship in South Africa, especially bearing in mind South Africa's history regarding dignity and citizenship. We had stated that citizenship is not just about legal status. It gets to the core of a person's identity, their sense of belonging in a community, and where xenophobia is a lived reality to the security of a person. The deprivation of or interference with a person's citizenship affects their private life and their family life, their choices as to where they can call home, start jobs, enroll in schools, and form part of a community, as well as their ability to fully participate in the political sphere and exercise freedom of movement. So if we look at the concepts of statelessness and some of the causes, in general, the effects of statelessness, rather, can be severe as it adversely affects and influences a person's ability to access basic human rights and to participate fully in the economic, social, and political life of a country that they live in and have always called home. We can go to the next slide, sorry. Nationality really is an entry point to access other rights, and it's described or been described as the right to have rights. Without a nationality, a stateless person is vulnerable to exploitation and discrimination, and they can't exercise their rights to health care, to education, just to move freely within a space, to work, or even vote. Think about how often you use your ID just in your day-to-day life, when you're filling out just a normal form anywhere. It's almost done as an absent-minded sort of exercise, right? Because you're just confirming your identity, confirming that I belong in South Africa, I'm recognized, I'm legally recognized within South Africa as this person. So you can imagine how even opening a bank account, signing a lease agreement, obtaining social assistance, or even marrying someone, things that we do or that we're open to doing with this legal recognition that so many people aren't able to easily access, and how it can prove to be impossible for a stateless person. Because statelessness really inherently results in a life of exclusion and marginalization, and a life without dignity because they're unable to access documentation. So what is it? What is this term that I keep going on about? To legally define it, in terms of Article 1, subsection 1 of the United Nations Convention relating to the status of stateless persons, a stateless person is someone who is not considered as a national by any state under the operation of its law. So some people can be born stateless, and others can become stateless. And some stateless people might be migrants. But in some scenarios, some stateless people have never even crossed a border and are stateless within their own country. That's known as in situ statelessness. It's also important to highlight some of the distinctions in, when you're assessing or determining stateless people between someone who is at risk of statelessness, and that refers to an individual who's not yet considered to be stateless necessarily, but faces a very high likelihood of becoming so due to a number of factors, like the lack of documentation or even just discrimination within nationality laws that may occur. And while statelessness is where you are just not recognized by a citizen, as a citizen by any country. So individuals that are considered at risk of statelessness lack the necessary documentation, really, or face circumstances sometimes that can make it difficult to prove their identity or their nationality link with the state. So statelessness can occur for several reasons, which, as I've stated, discrimination against, a particular ethnic or religious group within a law, or a law that's based on, gender or race. The emergence of new states or transfer of territory between existing states. You can see how that's almost playing out within the conflict in Israel and Palestine, for example. A gap or conflict within nationality law, or an inefficient civil registration system. Being undocumented is also not synonymous with being stateless, necessarily, but being unable to prove your legal identity and nationality due to a lack of documentation can place you, or place an individual at risk of statelessness. So it's important to look at some of these terms and definition of what citizenship, what a citizen is, and what identity documents mean. Because your citizenship is from the country that you're from, right? A person's citizenship is where they're a legal citizen, usually from the country that they're born in. But as we know, there are different pathways to citizenships that you can acquire. And citizenship also affords the state jurisdiction over a person, and also affords a person protection from the state. So being a citizen is where it's your status of being recognized under a custom or a law as a legal member of a nation or a state. With your identity document, that would be your document that's used to prove your identity and provide information on who you are as a person. So a stateless person would be someone who doesn't have citizenship or any legal recognition in the state. And in South Africa, the scope of statelessness, or a real determination on the number, or a factual account on the number of people that are stateless in South Africa, is really unknown because we don't have an established statelessness determination mechanism that really captures the relevant data for these individuals. Now, within the legal framework of South Africa for statelessness, we have, first of all, the international law through the UN Convention on the Status of Stateless Persons, as I'd mentioned, which is found through Article 1 on the definition of what a stateless person is. We also have the Constitution of the Republic of South Africa, which has multiple provisions that are in relation to it, but more specifically, Section 28.1, which highlights that everyone has a right, or a child has a right, to a name and a nationality from birth. The Births and Deaths Registration Act also is applicable in issues of statelessness, particularly pertaining to birth registration and the late registration of birth for individuals, which I'm sure will be touched on later. As well as the South African Citizenship Act, where we look at Section 2 and Section 4.3. Regarding the Citizenship Act, Section 2.2 really aims to prevent statelessness by granting citizenship to children that are born in the country, excuse me, who would otherwise be stateless and whose births can then be registered. So this provision is really designed to protect children from statelessness by granting them South African citizenship if they're born in the country and not citizens of any other country. And also, Section 4.3 also allows children that are born in South Africa to parents who are not South Africans or permanent residents to apply for South African citizenship by naturalization once they turn 18, provided that they've lived in South Africa since birth and that their birth has been registered. And so this provision really aims, or can aim, to address the issue of childhood statelessness, where children are born in South Africa to foreign nationals or non-permanent residents, and who might otherwise face difficulties in acquiring citizenship. But again, despite the existence of these provisions, there really have been challenges within the implementation, with some cases, which I'm sure will be touched on later, that just demonstrate the difficulties in ensuring that children are able to access citizenship and a full realization of their rights. So how crucial is documentation? And if we look at just the history of citizenship laws in South Africa, historically, I think this section I really want to touch on getting you to understand how a lack of documentation can become a growing problem within South Africa and the protection of stateless persons. And also understanding how a lack of documentation places children at risk of statelessness, right? So again, if we look historically how citizenship was used as a tool or a political tool to define access to membership within the South African state, really. Pre-constitutional legislation in South Africa really systemically stripped millions of black South Africans of their citizenship through unfair and very discriminatory laws, which really was an assault on the dignity and equality of many that lived in South Africa. But as we know, within our constitutional dispensation, citizenship is really protected through a number of provisions, more specifically through Section 3 of the Constitution, which speaks on common citizenship, as well as Section 20 of the Constitution that states that no citizens may be deprived of their citizenship. It's also important to note how, even through Chisuse, how the Concord has recognized the constitutional importance of this inclusion, especially bearing in mind our history of citizenship deprivation as well as exclusion. The Concords also emphasized that sometimes your nationality, or not sometimes, your nationality and citizenship really is a gateway towards other rights within the Constitution. And that this arbitrary or illogical distinction between citizens and non-citizens isn't in line with the Constitution. And we see that through the preamble, which expressly states that South Africa belongs to all that live in it. It's also emphasized that your identity and citizenship goes to the core of your dignity and your sense of belonging, right, within a state. So if we look at the evolution of civil registration systems in South Africa, much like in other Southern African countries, it can be traced back to our colonial history and the legacy of apartheid, where, again, civil registration and identity management was really used to enforce this social and spatial economic injustice that previously was brought on by the apartheid government. And now presently we have this automated biometric identification system, which is part of the modernization project that continues this sort of digitization of old manual records and the migration into biometric data, with the hope of creating this inclusive and integrated national identity system. But again, within this move towards digitization, it's important that we keep account to stateless persons who may not have, firstly, the recognition or any access to identity. So how do we move into digitization when I've never been recognized initially, right? So when we look at some of the contributors to statelessness, I won't delve into, the sort of factual background behind birth registration. I'm sure that's going to be touched on in the next slides. But I want to look at just more specifically into how birth registration can become a contributor towards this issue. And more so on how there is a lack of access to birth registration in South Africa. Firstly, we have issues such as parents having to hold valid documentation. So in that, the child's right, for example, to birth registration can sometimes be made contingent on a parent's documentation status. There was a High Court ruling in 2018 that ruled that the Births and Deaths Registration Act regulations were unconstitutional in that they ordered that parents should be able to submit documentation where it is available. And that can affect children whose parents might be unregistered South African citizens, or South African citizens with blocked IDs, and undocumented refugees or migrants. As we saw in the presentation previously, you can see how the maladministration of the Department of Home Affairs itself can sometimes contribute to the undocumented status of refugees and migrants. Again, there's also discrimination that can occur against children that are born to married parents. And in 2021, the Constitutional Court had declared Section 10 of the Births and Deaths Registration Act to be unconstitutional, with the effect that mothers and fathers should have equal rights to register the birth of their children, despite the marital status of them. We have arbitrary or discriminatory and exclusionary DNA testing, where a DHA circular within 2014 required proof of paternity in the form of a DNA test result if one parent of a child is a non-South African citizen, and where a DHA official had a reasonable suspicion regarding the paternity of a child. And so that fosters discrimination against children that might be born to a non-South African parent, for example. And then finally, just the backlog and unreasonable delays that we find in the processing of late registration of births. If we move to citizenship, these are, I've just highlighted here some of the provisions that we have regarding citizenship law in South Africa, more broadly and generally. But again, if we move towards the contributors to statelessness itself, we have Section 2.2 as a provision within the Citizenship Act that provides that a child that is born in South Africa and who would otherwise be stateless is a South African citizen by birth. But one of the issues in this is that the department hasn't published regulations that really, or what we believe final regulations, that really prescribe the administrative process for these applications, how these applications go about, or even in establishing a statelessness determination mechanism to determine someone's eligibility to be considered stateless. And in 2018, a high court had actually ruled that it's not in the best interests of a child to remain stateless indefinitely, and had ordered the Department of Home Affairs to publish the necessary regulations. When we move to Section 4.3, which would be naturalization as a provision, again, this is for, or placed for children who are born in South Africa to parents who are not South African citizens or permanent residents and have lived in South Africa all the way until 18 years of age. Again, we have cases or case law that really establishes, firstly, the requirements to be considered as an applicant for naturalization. But the department hasn't published regulations prescribing, again, the administrative process in processing these applications. And within one of the court cases, it's Jose, if I remember correctly, the Supreme Court of Appeal had ruled that the department must accept applications on affidavit, as well as to publish the necessary regulations. Now, last year, on the 12th, no, not last year, 2023, sorry, on the 12th of June, the DHA had promulgated regulations that they deemed to be final, but they are deemed to still be problematic for a host of reasons, which I suspect CDH will touch on within their presentation. If we move to unaccompanied and separated migrant children, could you go to the next slide? Undocumented children who are separated from their parents, for whatever reason, are also particularly at a high risk of statelessness because they don't have a parent available to assist them within documenting themselves, right? So even if a friend or a relative of their parents is caring for the child, it can be challenging for that person to obtain documentation for the child, since the legal guardian or the biological parent's presence would be required by the Department of Home Affairs to get a birth certificate or passport. And when we talk on unaccompanied and separated migrant children, we're talking on these groups of concern. being stateless migrants who might not be born in South Africa, being migrants and immigrants that can be stateless due to not acquiring citizenship in any country, or a loss or deprivation of citizenship, or state secession. Again, we have foundlings, and foundlings are children that are found on the territory whose parentage or citizenship may be unknown. And then we have vulnerable foreign minors, who may be unaccompanied foreign minors or orphaned and abandoned foreign children. And they often don't have documentation from their birth country or any legal guardians, again, to assist them with their birth registration. So even if they were to go through the children's court proceedings, the proceedings don't ordinarily deal with the child's immigration status, particularly. And so this really creates a risk that this person will then become stateless as an adult, for example. So in assisting children that are deemed or unaccompanied separated migrant children can be challenging, and it really it requires this creative use of a combination of laws, whether it's international, customary law, human rights law and our principles, as well as the South African Constitution, as well as citizenship and immigration law and administrative law. Gaps in our South African legal framework as well and our practice can really result in many USMCs remaining in sort of a protracted legal limbo without any durable documentation options or legal identity. And again, these difficulties that they face can really worsen once they age out of the childcare system, because they can't further their education or can't get jobs, and also become at risk of deportation and detention. Again, many of them can be placed in these child and youth care centers and can't return to their country of origin because it's not in their best interests. And the child might not have any knowledge or memory even of their country of origin. Or the child has also just lost any meaningful connection to the country of origin that they come from, and that they have no family, no social or economic ties to it. And so they're often left with two options to becoming documented, in that they can go through an asylum claim. And again, we've heard the problems that exist within the asylum protection system, and more particularly the claims in relation to children. Or an immigration application, in that an exemption application through Section 31(2)(b) of the Immigration Act could be done. But that, again, can sometimes be an unclear process, and also there can lie ambiguity as regard to what are the special circumstances that necessitate granting this person this exemption. There's also quite a lengthy or indefinite waiting period. And again, these type of applications are at the discretion of the minister, really. So there's no real substantive option, which is why I say it requires this creative use between the laws that we do have. So if we were to assess statelessness, right, and in making a determination for yourself and clients, please could you go to the next slide? We would then need to ask, really, does this person qualify for citizenship under the law of any country, right? And if not, they may be stateless. If the person does qualify as a citizen under a literal reading of the law, then one can ask, what is the viewpoint of the state? How does the state really see them? Does the state implement the law in a way that actually gives citizenship to the child or to the person? And this requires really attempting to ascertain whether the state considered or considers this person to be a citizen of the state. And if the person qualifies under the law, but the state doesn't view them as a national, then the person is also stateless in terms of the 1954 convention. And finally, those who aren't stateless, but may be described as above, can also be classified as persons that are at risk of statelessness. Okay. So really, in closing, I think it's important that we look at the socio-political time that we're living in, which is very scary, and we see a lot of states moving towards a lot of these right-wing sort of policies and thinking and ideologies, and this quite bluntly move towards fascism. And we've even seen it operating within South Africa, and the department publishing this white paper previously on citizenship and immigration, and looking towards this complete overhaul of the migration system within South Africa, right? And it's important that we note it, because the white paper really stands in contrast to the rights that are afforded to migrants under the Bill of Rights, and some of the protective legal and policy frameworks that are afforded to not only asylum seekers and refugees, but the adverse effect that it would have on stateless persons because of the protections that they have under citizenship law becoming more stringent. I think the publishing of, the paper, and just really constantly analyzing the time and the space that we are living and working in, must also be seen against our own backdrop and our socio-political context. There's been a huge surge in xenophobic attacks that we've seen since about 2008, really. And these institutional policies and exclusions towards migrants, but more particularly towards Black African migrants, right, and citizens, from really accessing work opportunities or even just getting social assistance. So it's really important that us, as legal practitioners and human rights advocates, that we continue not only, the litigious aspect of work that we do, which is important, but also just the advocacy that we do within the broader issue, not only within refugee and migrant rights, but towards statelessness, and use the network that we have to really advance our broader goal towards the eradication of statelessness within South Africa and more globally, really. I think I did go under time, but maybe this gives us more time towards, just discussion, some thinking points within the room. Unless everyone wants to rush for lunch. But thank you. Yeah.
Thank you so much. The name is Nande of Meshe Attorneys. One of the agreements that we're busy with, we've got an SLA with the Republic of Angola. So they requested us to look into Section 6, which is the dual citizenship aspect. Now, we're kind of like stuck, because I believe that there's a recent case that is before the Constitutional Court where that section is being challenged in terms of the validity, because now people migrate or they relocate to other countries and they get citizenship of other countries, and then automatically they lose their South African citizenship. So that has been challenged, and it's my understanding that it's before the Constitutional Court, but the judgment has been reserved. So I wanted to check, are there any recent developments around the judgment? Because now we're kind of like stuck, because we can't give the legal opinion to the Republic of Angola because we have this matter pending before the Constitutional Court. So I just wanted to find out if you've got any recent developments around that. Thank you.
With regards to the judgments itself?
Yes, the judgment itself, because it will then inform the validity of the Section 6 of the Citizenship Act, so.
What is I'm not familiar with the case. Do you know the case?
It's the DA. It's the DA versus the Minister of Home Affairs. Yeah, I think it's 2023 case. Yeah.
We're
Still awaiting, ne? Oh, okay.
That we've become aware of. But I wonder if it's also, made in light with regards to, the Angolan secession that had happened. When was that? Within the late 1990s and early 2000s. And so that could be a point in looking at regarding the opinion back to, and this is to the Angolan government, you said. Yeah. I think that would be the first point in looking. I don't know if you're familiar with it, with regards to what it meant for South African citizenship law. The Angolan secession. So many, am I correct? You're looking at me funny? Yeah. So many Angolans had fled South Africa within the late 90s and early 2000s, which meant at the time of secession, they had been living in South Africa for quite a period, I think about 18 years or more. And so after the secession had happened or had announced, several of them had then returned to Angola with the assistance of the government itself, actually. So I'm assuming that a lot of these clients, again, had probably decided to remain. Some had decided to remain in South Africa after having lived in the country for quite a lengthy period of time, and had been raised and born and raised. Their children had been born and raised within South Africa. So I think that's a point to look at with regards to in formulating a legal opinion towards them. But regards to the judgment, I don't have any real developments on it presently. I don't know if anyone else in the room might have any idea. No, but if we do, I'm happy to get back to you on it, or keep in contact.
She's responded to say they're still awaiting judgment.
Yeah.
Thank you.
But even post.
Yes.
Yeah.
Palisa, I just want to understand the statelessness. I'm just going to make a scenario here. My mother is a Lesotho citizen. My father is a South African. I'm a child who was born in South Africa. My father passed on before I'm being registered, and my mother does not have any documentation. What do I do as a child, or what do I do as a family member staying with this child? Secondly, Home Affairs ask, is the second part now. Home Affairs ask a certain family member to do a DNA test. I am unemployed. I'm staying with this person who does not have a citizenship. We all unemployed in the family. Where do I refer this family since they're unable to pay for DNA testing?
With the mother being from Lesotho, father South African, you'd stated. The mother doesn't have documentation. Where was the child born? Here in South Africa. And how old is the child, for example? Okay. Is the mother registered? No. Okay. Is the child 18? 13. So that would, I believe, would be a 2-2 application. Yes. If I'm hearing you, sorry, my brain is everywhere at the moment. Regards to the DNA testing, you can refer them to Lawyers for Human Rights, for example. While we do have limited resources, these are the type of cases that we take on and can assist with the DNA testing. What is the first question? You want to understand what the legal position is of the child?
Yes, we want to understand what do we do in this situation where we find ourselves stuck. We go back and forth, calling Home Affairs. What do? We don't have answers. I believe we should all have answers. I've got another scenario, but because this one, we are stuck with this one, we need to resolve this one first.
Hi everyone, I'm Tandeka, so I'll try and contribute a perspective. In terms of the citizenship of the child, Lesotho recently amended their provisions on dual citizenship to allow Basotho citizens to hold dual citizenship, because they also noticed with border communities which have children born to mixed nationality parents, South African and Lesotho, South African officials will tend to push the children to Lesotho and say register them. So they've removed this barrier by saying, listen, we'll accept dual citizenship. But in terms of the claim to citizenship that the child has under law, it's both Lesotho citizenship, because of Lesotho citizenship law says if your mother or father is a citizen, you inherit their citizenship. And they would also inherit South African citizenship because it also says if your mother or father is a citizen, you inherit South African citizenship regardless of where you're born. Now, because this is under the operation of law, nothing further is required. You are a citizen by operation of law. But in practical terms, to have your citizenship confirmed, you then need to access birth registration so that you get your birth certificate, you're entered into the National Population Register, and you're issued your South African ID number. And that's where the challenge comes, particularly for children who've been abandoned or orphaned. And what the birth registration laws say is that there's still a solution for such children. Social workers must step in and facilitate the registration with whatever available information is there, either from relatives or whatever caretaker has taken in the child. And the social worker must register the child. If the child doesn't have a name, they are responsible for giving the child a name together with the family if the family is involved. If the child's parents' details are unknown, they're also still required to register the child and leave those places blank. What must happen is that the child must leave with a birth certificate because they have a right to a birth certificate. And then if it does so happen that the citizenship claim becomes obscured or uncertain, then we fall into the sphere of statelessness. The child might be possibly stateless. But again, as Palesa has said, Section 2.2 still saves the child because it says if a child is born in South Africa and they have no other citizenship, we must still give them South African citizenship. But of course, now we know what's on paper is not what happens in practice. And then with the DNA testing, we've been doing a lot of advocacy. So we don't like to advertise that Alichaya has been funding DNA tests because it's dependent on crowdfunding. So I'd also appreciate if you could also circulate our global giving link for anyone who might want to donate towards DNA tests for a child to be able to access birth registration. But we've been advocating for the department to either scrap DNA testing or to use alternatives, like for instance, having waivers or subsidies for families that cannot afford the DNA testing, especially when the DNA test becomes the only barrier to the child being able to access the birth certificate. So this is one area of collective advocacy we could also be pushing for, this issue around DNA testing as a financial barrier to birth registration. Another thing that I think we should be advocating for, and which I think we've neglected, is the recognition of informal adoptions, because we know Black families often take in children without adoption or guardianship orders. Now, the Birth and Death Registration Act and its regulations require some sort of formal proof that you are the custodian of this child. And this doesn't necessarily translate into the context of how we Black people live and how our families work and function. So I think it's also something to be advocating for, to say, let's not create an additional barriers for grannies or aunties to be going to the children's court or to the high court to get adoption orders to register a child. But you recognize the informal or customary ways in which people look after children, and you recognize that as an ability of that person to be able to facilitate the child's birth.
I just wanted to comment. I think Ausi Tandeka answered my initial question, because we have so much problems and challenges in practice. You find that when we are dealing with such clients, especially in Bloemfontein, Lesotho, Maseru being our nearest border, you find that when we have clients of such nature, if they speak Sesotho, automatically they are deported to Lesotho. And it becomes such a problem because you find that they are deported, and when they get there, they don't have any family or any relations for that matter. And I think it also goes to what the lady said about us also involving other stakeholders, because they're so clueless, especially at the NPA, because you find that if you are speaking Shona, automatically then they believe you should be from Zimbabwe. So those are the stereotypes. Thank you so much.
Capacity building workshops that we do within our networks. It's important to sensitize these stakeholders towards sort of the, what can I say, inherent biases that they might have with these clients. We've decided to have a dedicated focus towards women in statelessness in South Africa. And so we are launching our campaign, which is titled Her Document, Her Dignity. And just looking at the inherent dignity that comes with women in South Africa having, and the intergenerational link that exists, or prejudice that exists for women that don't have access to documentation or the legal recognition in South Africa. And so we're going to be hosting our campaign launch next week of Human Rights Fest. And hopefully if I get everyone's emails, we can send the invites to everyone in the room. It's going to be held on Friday at the Women's Jail, Friday the 21st, at the Women's Jail at Constitutional Hill. I will distribute the flyer for everyone, but it would be really great if everyone could come in and join us and hear the stories from the women themselves on how this issue does affect them, and how we can also just build our network in assisting them. So I'll steal the register, actually, with everyone's email.
Thank you, Palesa. And thank you, everyone, for the wonderful interactions that we have had thus far. So right now, we will break for lunch. Please enjoy and please remember to network with your fellow attendees. We will reconvene again at 1:30. Welcome back. All right, so our next session focuses on migrants' children's rights to birth registration. Daphne and Advocate Steenhuisen will take us through this issue.
Good afternoon, everyone. My name is Daphne. I'm a legal consultant at probono.org. I am an advocate for children. I enjoy working with children. I do anything child-related. And amongst the matters that we deal with, I deal with undocumented children. So we are just going to take you through the badge registration system of children on the move, the challenges they are facing, and how we can collaborate as stakeholders to see how we can help them. I was talking to Nyelete just now. I said she gave us a very, very difficult task. Number one, speaking to lawyers. Number two, speaking to them when they are very, very full and tired. So but Eugene promised me that she's very wide awake. So I know someone in the room is just listening to us. So I didn't say next slide, but anyway. All right. So the issue of birth registration / undocumentation doesn't only affect non-nationals. Some people call them foreign nationals, but it also affects even South African citizens themselves. Believe you me, we did stats last year in our OK project, One Child a Year project. We realized that out of 3/10 undocumented children are born from South African parents. 4/10, they were born from non-nationals and one South African parent. And the rest is asylum seekers, migrants, refugees, stateless. So this issue is affecting a lot. And we discovered that because of the inter-country migration that is happening, now we are having a lot of foreign and national marriages, that is inter-foreign marriages. And you find that we have situations where one parent is South African, the other is non-South African. So I'm just going to deal with what is birth registration and the laws in South Africa and the challenges that we are facing. And we see the documentation of a child is very important because it gives the child the right to access everything in their life. In South Africa, it is protected by the Constitution, it is protected by the Birth and Death Registration Act, and also there are international treaties that also protect the right to birth registration. So the most intrinsic right that a child can have is the right to a document. Next slide, please. This is the international law that deals with the birth registration. South Africa is part of the United Nations Convention on the Rights of the Child. We are also part of the Covenant on Civil and Political Rights. We are also part of the African Charter on the Rights and Welfare of the Child. Now the question comes, as South Africa is part of all these conventions, are we really doing our best to ensure that all the children are children's birth is registered here in South Africa. Our Constitution, Section 28(1)(a), it provides that every child has the right to a name and a nationality from birth. My understanding on this is that every child, it's not saying a child who's born to a national, a child who's born to a non-national, but every child. As long as you are a child, you have a right to a name and you have a right to a nationality. Then we have the Birth and Death Registration Act, which deals with the registration of birth here in South Africa. It provides that a notice of birth of a child should be done within how many days? Thank you. Within 30 days when the child is born. That is your section 9. And after 30 days, what happens? Thank you, advocate. So after 30 days, it's going to be a late birth registration. I'm just trying to check if we are at work now that we had our lunch. All right. So in terms of Regulation 3, notice of birth of children born in South Africa, these are the documents which accompanies the notice. Your proof of birth, which is attested by the medical practitioner, the biometrics, that is the fingerprints, the footprints, the parents' fingerprints, a copy of ID or passport of the parents or guidance, a copy of a valid passport or visa permit if one parent is non-South African. Where applicable, maybe when we are dealing with cases where a parent is deceased, we may be requested to provide a death certificate, and where applicable, a marriage certificate as well if the parties are married. We continue with Regulation 8 of the same Act. It deals with the notice of birth of children born to non-South Africans. The notice must be given 30 days, within 30 days. For now, our law does not provide for a late birth registration of the children born to non-nationals. You should ensure that we encourage our clients to register the children within the 30 days. These are the requirements. They need the proof of birth. Some call it the notice of birth, the one that we get from the medical practitioners at the hospital, and also a certified copy of the passport, valid identity document or passport with a permit or visa, and also an asylum permit if it's asylum seekers, a death certificate, marriage certificate. Then, if they meet the requirements, the department will issue a handwritten birth certificate with no ID number. I'm very interested to see what's going to happen with the handwritten birth certificate now that the Ministry of Home Affairs has started to do the digital system. So we are very interested to see if they are going to also digitalize the so-called handwritten birth certificate. I'll speak on the challenges that we have on the handwritten birth certificate a bit later. So that's the South African law, your constitution, the Birth and Death Registration Act, as well as the regulations. So when we are in our project, these are the challenges that we have identified that are being faced when we want to acquire the birth certificates for migrant children. Other people, they call them children on the move. Other people, they call them children born from non-nationals. But I also have another category to add, a child born from one national and a non-national. All right. So they have several challenges. The challenges include legal and documentation barriers. The lack of legal status, that is when their parents are undocumented or doesn't have any legal status here in South Africa, it makes it very, very difficult for them to register the birth of their child. I can give you a lot of examples because we work with this every day of our life. Then also the strict documentation requirements. The Department of Home Affairs requires valid identity documents, passport, asylum seeker permits from parents. And sometimes the parents might not have them. For example, the parent came from their country of origin and they are still trying to come in the system. I come from Zambia and I am already pregnant. And I'm trying to ensure that I have documentation. I give birth. Then I need 30 days to make sure that I register my child. Just imagine what happens to that child. I remember a colleague earlier also mentioned about the issue of the asylum permits which are being rejected. Imagine a mom who is pregnant. She has been on an asylum permit for the past 10 years. Now she went to the department. They say, sorry, we see that you are only here for economic purposes. We are rejecting your asylum permit. She gets birth tomorrow. We have only 30 days to register the child. Then what's going to happen to the child birth registration? There is also late registration difficulties. I think I have spoken about it. They need more documents, which I've already spoke about. And the process is very, very costly. Sometimes it even goes to the extent of the Department of Education. All right. Yeah, I work with them every day, so yeah. The Department of Home Affairs wanting to do verification of the parent who's got a document. Say a parent has an asylum permit, they have a work visa, they want to do a verification to ensure that their documents are legit. And the verification process takes forever, and sometimes it's not done at all the DHA offices, which is problematic. All right, those are the challenges as well. The fathers are being denied the right to register the birth of their child. In South Africa, previously, they never disputed they never disputed the maternity. That's why they were allowing the mothers to register the birth of the child. If I just have a child today and DHA asks me, where's the father? I just say, I don't know, it was a one-night stand. They don't have a problem. They register the child and life goes on. And now, if a father who is not married to me wants to come and register the child, they could not be allowed to register. Even I'm married to him, he could not register the child without my consent. I had to be included. However, we shortened this case. We call it the Naki case, the Naki judgment. I know lawyers, they want us to give them the citation. There you have it. The matter for the Center for Child Law, where the court decided that unmarried fathers can now also register the birth of their children. They won't need the consent of the mom. However, they will need DNA testing. I'm not sure if we need to challenge that or not, because maternity is never disputed, but paternity is a problem. When it comes to a death, they want the DNA test, but if I just go as a mom, there is no need for a DNA test. So we see what the court ruled there. The court held that Section 9 and 10 of the Birth and Death Registration Act did not prohibit an unmarried father from registering a child's birth, and the section could therefore be interpreted as constitutionally compliant. Then it also held that even though Section 9 empowers any parent, including an unmarried father, to register their child's birth, the exercise by an unmarried father of this right is subject to the mother's presence. That was then. And then the Constitutional Court confirmed the invalidity. So now in practice, an unmarried father can register the birth of their child. They can register the birth of their child, but DNA testing is a requirement as well. So in practice, this is what we do at our offices. If an unmarried South African father comes to us for assistance, we have a letter that we write addressed to the Department of Home Affairs, where we inform them of this case, and we inform them the unmarried father's rights to register the birth of the child. And they often refer them to the DNA testing. So that is working. However, we are finding that there is ignorance of the law when it comes to the Department of Home Affairs. They don't know what's happening in the laws, and they are not also implementing the judgments. For example, we went to Randburg Majors DHA the other day with a client with a blocked ID. And that was last year when they had issued the issue of the PAJA representations we needed to do. We asked them for how we do the format of the representations, the judgment, the PAJA. No one knew what was happening. No one. And we are also finding difficulties in lack of information within DHA in that when it comes to the requirements of birth registration, they are not really following what is required from the regulations. Each DHA is doing their own thing. You go to this DHA, they say we want A, B, C, D, and E. You go to there, they say we want A, B, we don't want E, we want C, we want F. So it's something that we are trying to liaise with the Department of Home Affairs. We know if you have worked with them, it's just like you are knocking at a wall. No one comes to the party, but that is also a challenge that we are encountering when we are doing birth registration matters. There's another case as well. Thank you. This is another matter that you can refer to. It's the matter of COSA and the Minister of Home Affairs. It was a late birth registration application. This child was born here to non-nationals who didn't have any documentation, and they wanted to register the birth as well as issue an ID by naturalization, and Home Affairs had refused them several times. However, upon going to this court, the court ordered DHA to register the child and also to issue them with ID document and to register them on the National Population Register. So it's very seldom that the DHA comes to the party without us doing litigation. Of course, they speak about us exhausting internal remedies before we go to court, but you do anything you are able to do. I'm not sure other colleagues how you are operating. We'll speak about it when I'm done. But DHA is a problem. If we do litigation, that's when they come to the party and they assist. And even when you have the court order, it's also difficult for them to adhere to the actual court order. So we'll speak more on how we can assist each other there. But this is a nice case that you can also refer to when you are addressing your issues with the Department of Home Affairs. Whilst I'm here, I can also help the colleague who was speaking about the issue of the child who is stateless. This is also what can help. You can approach the Children's Court with jurisdiction and ask them to appoint a social worker to do an investigation to declare the child in need of care and protection. With that request, also ask the court to do a 4618 in terms of the Children's Act. That is to order DHA to issue a birth certificate to this child who is in need of care and protection. That is another route you can do. Tandeka already spoke about the other routes, which I'm not going to speak about. All right, then the issue of handwritten birth certificate. This is problematic because the handwritten birth certificate is not on the National Population Register. I remember one day we had a client that came to our offices, and the mother is an asylum seeker holder who is now even on refugee status. She had a handwritten birth certificate for her child. She came like really, really breaking down. And my colleague is coming to me. She's saying, this mom is crying. She's saying she wants a yellow paper. She was just saying, I want a yellow paper. The school is refusing to take my child. I need a yellow paper. Then she was saying, I don't know, what is she talking about? Then I said to her, she is saying she wants the digital birth certificate. So our clients don't understand when they have a handwritten birth certificate, they don't understand that the child has a birth certificate. Of course, it's handwritten and it doesn't have an ID document, but it doesn't mean that the child is not documented. The child is documented, however, they can only get naturalized upon the age of 18, and if they've never claimed citizenship in the country of origin of the parents, if they've never went to the country of origin of the parents. So I know my colleagues from CDH will speak about naturalization. I'm not going to touch on it. Then if the handwritten birth certificate gets lost, they don't reissue it. That's the end of it. Then also, South Africa does not automatically confer citizenship on birth. You only get citizenship by naturalization upon the age of 18, and it's not automatic. There are a lot of requirements they need. And also, they may do interviews. I can give an example. We once had a child who was in need of care and protection. Child went to an interview, and DHA refused for social worker to be part of the interview. Then the child was asked, all right, so if we give you a birth certificate, an ID document, and a passport, what are you going to do? Then she said, oh, that would be great. I'll visit my grandma in Mozambique. Then they rejected the application. They said, let's reunify this child. The child wants to go back to Mozambique. There is also DNA testing policy. DNA is being problematic. I also heard previous colleagues speaking about it. The DNA issue on unmarried fathers. We do have a circular that we can share with everyone where we have all those DNA test labs which are recommended, which can assist DHA with results. However, we have, for example, your Empathy, your Lancet, they can do the test, but they are very expensive. We're looking at $3.5 per person for their DNA test. I'm not sure about you colleagues, but with us, we work with pro bono clients. They don't have money. I also don't have 3.5. Maybe I have 3 children times 3 times 4. It's a lot of money. Then we have the national lab, which can also do DNA testing. However, now they are blaming everything on COVID. They have a backlog. It was because of COVID. And to us to get the results, it's taking forever. So you find that we end up with some children who will become stateless. For example, a child is turning 18 in the next 6 months. For some odd reason, nothing was done before for this child to be documented. And now we need DNA testing. And we don't get it within that period. And say we have a court order from the children's court, it's going to be a problem. After 18, children's court no longer has jurisdiction. And now we have a problem with assisting the child. Then the issue of obtaining maternity certificates, this also is a problem, especially when we are dealing with non-nationals. They go to the hospitals, and the hospital will say, settle the maternity bill first before we can issue this certificate. Oh, bring the father if the father is not in the picture. And if it's the dad, who is an unmarried dad, he's South African, he goes to get the maternity certificate. And I'm not sure what, I always say to advocates, it's always the women who are wrong. I don't know what's wrong with us. I go there, I don't include the dad in the notice of birth. I don't even on the clinic card to say he's so and so. He goes to the clinic, they say, sorry, we don't see you here. How do we know who you are? We can't help you. So this is also a problem. And for some, they say, we need a social worker's letter for us to assist you to get a maternity certificate / a notice of birth. So this is a bit problematic. The way we are trying to deal with it, although it's not really 100% efficient, we also address a letter. We do have DSD social workers we work with. We can ask them to address a letter as well to enable us to assist the client. But when it's a South African father, we are winning because we are saying the father has a right. Give him the maternity certificate. And also, public health service is free from 0 to 6. So please do what you need to do and do away with the policies. Next slide, please. Yeah, then it's DHA with their inefficiencies. I don't know, colleagues, did anyone ever one with dealing with the Department of Home Affairs? Maybe you can give me a plug. Because we are struggling with this department. Only in Messina, we also run a project in Messina that's only where we managed to get the DHA to bend. They're assisting us effectively, everything is going well. Other than that, all the other offices this side were still struggling. We even went to several meetings with the Department of Home Affairs, with the other generals, but we're not really getting help. So when we are going to contemplate on the way forward, please help me with the Department of Home Affairs. They don't implement judgment. They are also ignorant of the law. There's no uniformity. No one wants to take responsibility. It's even difficult for a client to go with a letter coming from your offices just to say, here's the letter, I need to do a DNA test. No one wants to stamp the letter back. No one wants to take responsibility. And there's a lot of corruption. Everyone wants to get money from our clients. I remember a client, this issue of lack of knowledge. We have a client, asylum seeker child, had a handwritten birth certificate legit from Home Affairs. Birth certificate did not have an ID, as we all know. Then someone from Home Affairs said, I can help you to get a birth certificate with an ID number. Client got birth certificate with an ID number. Child went to write matric last year. Child is applying for university places, only to find that the ID document, the ID number is invalid. So now we are stuck on how we assist the child. Next slide, please. There's also the issue of language barriers. I won't touch more on it, my colleague already did. Where our clients, for example, they go to an interview and because of language, they don't really understand the questions which are being asked and they end up saying other things. Then also there are financial constraints. Our clients, they don't have the money to pay for legal fees. They don't have transport costs. Tandek, I remember, and Palisa, we had a training at LHR in Pretoria with refugees, and one of them stood up and said, why don't you have offices here, you pro bono people, why don't you have offices in Pretoria as well? You want us to transport to come to Johannesburg, and on our way, there are roadblocks. Then the police, they take us, and we are already arrested. So I'm just trying to give you that these are real life problems. Then there's fear of deportation. This we are facing mainly in the Messina area, where a parent will not go to register their child because they are scared that if they go there, they're going to be deported. Or they are going to be asked, where's your paper? For example, dad is South African or mom is South African, the other parent is non-South African. They fear that if we go together, then the other parent is going to be detained or deported. Then there is the denial of nationality. If there is statelessness, I'm not going to speak about it. My colleague already did. Then there is the lack of access to rights. Without a birth certificate, children may struggle to enroll in school, receive medical care, or access social services. I'll speak about the issue of enrolling in school. On enrolling in school, we do have the Phakamisa judgment. it's a case where the Center of Child Law as well, where the court decided that every child has a right to education, whether documented or undocumented. Every child has a right to basic education, but still the departments are not implementing this. We are still having a problem, and we are trying to rectify it. We spoke to the Minister of Home Affairs last year around October, around this, and it seems there have been communication between the departments, because on the 5th of December last year, there was a circular that came out, and it was addressed to all the Department of Education officials, where they were saying, we've got this judgment. Why are we still having a problem with enrollment and admission in schools? But still it's not being implemented, because around the time where matrics were writing exams, we had an influx at our offices. They needed assistance. When we opened in January, it was the same thing. But this is what we do. When dealing with Home Affairs, with the Department of Education, believe you me, they don't really know what's happening out there in the laws. So sometimes you just pick up the phone, you speak to the principal, here's the law, please admit the children. You write a letter as well. You do an affidavit just to confirm who the child is when they are born. A child can write matric, a child can be admitted in school, a child can get a matric certificate. So yeah, this is us here as lawyers, as stakeholders. For us to be able to effectively assist the people on the move, we need to do some advocacy, and we need to make sure that we can see how we can assist the lawmakers to enforce the laws, and also to marry our South African laws with the international conventions. This year, as probono.org, on the 11th of June, we are going to celebrate the rights of the child, and we want to do a reflection and see if really these laws are being implemented. So we intend to call all the policymakers and all the implementers on this platform to see if they can engage with us, and let's see where are the problems, how can we help them, and we move forward. So basically, this is the summary on birth registration of non-nationals. I didn't include the solutions that I was thinking of, reason being, we've already spoken with the Department of Home Affairs on their problems, and we are trying to wait to see how they are going to implement or to react. So I also want to just hear from everyone on the floor on how we can also deal with the challenges that we are facing, or how you are dealing with them in your area of practice. Then we can take it from there. I said here, I won't read everything, but you see on the last sentence, I said, we are looking forward to a South Africa which will have been transformed, and where the DHA is, it moves from being a department of horror affairs to a department of happiness affairs. Thank you so much. Any comments? Questions? Recommendations?
Oh, okay, thanks so much, Daphne. That was very informative. As you're presenting, I was thinking, just in this room alone, there's so many of us who do work around birth registration, and those of us not in the room who are also doing work on birth registration and taking different approaches. Some are litigating, some are doing advocacy, some are engaging with the department. And UNICEF and UNHCR has set up a national birth registration task force that kind of brings everyone in terms of collaborative efforts to address issues around birth registration in a more holistic way. So I'm wondering how we can actually strengthen those collaborative efforts, because you might find all of us have good intentions, but if one party is speaking to the department and engaging, while another is litigating and changing the act and the regulations, you might find that our efforts are counterintuitive. So I was wondering how we can actually, have a shared platform where we are continuously engaging on this issue and ensuring that, there's a cohesive approach from civil society. And I think that task force is one of those platforms that we should be exploring and adding additional stakeholders who are not on that platform to the platform if we think it is a mechanism through which we can achieve this sort of cohesion and collaboration. And then the point around the COSA case, it's been interesting because I think it's also an important point that Palesa noted around digitalization. What we actually notice with COSA, and it's something to be aware of when you speak about birth registration, the civil registration system, and the move to digital ID, is that Home Affairs actually doesn't have a function in their system to implement Section 22 orders. That's what we discovered. And you'll look in Tebogo's case, the COSA case, they actually ended up registering him under Section 4.3 instead of Section 2.2 because they said that their system requires a special function. So I think it also needs to be worked into all our advocacy efforts to see what the impact of digitalization is on the different elements around access to documentation and citizenship.
I think we need to include everyone on the task force. We are already there. Anyone interested, we can also ask them to be added. And maybe, like Mr. Shafi said earlier, and also take it further. If DHA is not hearing us, let's take it to the Parliament portfolio and see if we cannot be heard there. Anyone else? I want to give Advocate Steenhuisen a chance. Yes, ma'am.
Thank you for the presentation, Daphne. With regards to the stateless children, you advise that would rather also approach children's court with jurisdiction, correct? I'm just wondering, you did say that you deal with children, but the reality is that stateless children become stateless adults. If a person is already now at adult stage, and now we can't now possibly approach the children's court, what do you advise in those circumstances? Thank you.
I think Thandeka can agree with me that we can rely on the COSA matter, the one that I've given you.
Okay, so we've also been making efforts in sort of the regional advocacy we do in Southern Africa to identify Home Affairs officials who are appointed as statelessness focals. And in South Africa, they have one. He's the Director of Citizenship, Mr. Richard Sikakane. So sometimes with those complicated cases, it's worth it to write a motivation to him and say, please, can we meet for further guidance? Or like a case management meeting, how do you suggest we move forward with this case? When that doesn't work, then litigation becomes the last recourse. But we found that sometimes that assists. There are various provisions in the Citizenship Act, the Section 2.2 that we used in COSA and that Palesa spoke about, but there's also Section 15, which speaks to citizenship in case of doubt. So you can also write representations. It doesn't really say what should go in those representations, but you can say for these factors, this person has a link to this country, there's a reason to believe this person is a citizen in case of doubt, and we request the minister to issue a certificate. Then when there's no decision on that request, judicial review.
Thank you so much for your presentation. I really enjoyed it. I'd just like some clarity when it comes to statelessness. I mean, I often hear it distinguished between, somebody who is stateless and someone who is at risk of statelessness. So my question, I guess, would be how would the regular person come to know that they are actually stateless? Because it does seem like probably a bit of a privilege to know that you are stateless, because you could live your whole life thinking that you're fine, and it's only until you have some sort of access to legal services or legal representation that you come to learn that you are stateless. So the first question would be, what is, I guess, the difference between being stateless and being at risk of statelessness? And how do you determine that outside of, you've come to a crossroads where you need a document which you don't have? I don't know if my question makes sense.
All right, I can just say when you are stateless, you don't have any country that recognize you as their national. You agree with me? And when you are at risk of being stateless, this is how I can respond to you. When you are a vulnerable child, a child in need of care and protection, and you came from wherever you came from, and you are not recognized, and maybe you come here in South Africa in need of protection and care. Alternatively, born from South African parents who are maybe never documented at all. You are at a high risk of being stateless. Let me give a chance to Advocate Steenhuisen, otherwise tomorrow I won't have work. Okay?
Good afternoon, everybody, and thank you for the opportunity. It's always nice to see so many young people, especially, who are interested in this very difficult and challenging field of law. And we do struggle to get LPs, legal practitioners, to take on these matters because it is emotionally draining. Now, what Daphne and I decided to do is we chose 4 cases, and if the time allows it, I will do all 4. If not, I will just stop where the time needs me to stop. And we will talk about the practical difficulties that we have when children are not documented. And it becomes so much complicated when one or both of the parents are not documented, whether they are non-citizens, non-nationals, or even South Africans. It is really such a big mess, to say the least. And if we only had to do our legal work, it would have been fine. But now we have to deal with the Department of Horror Affairs, like you all know. And many times we have to deal with the Department of Social Development and the social workers that are also not equipped to do the work properly, efficiently, and also not with the police. So the world of the child is not only the children's court. It involves so many other state departments, and maybe it is time that we will go to the public protector and see whether we should use that route as well. But let me turn to a case where there's a grandmother, a teenage mother, and baby B. And the grandma had a very tragic story. Apparently, because she was only 18 months old, she and her parents traveled from Lesotho to South Africa. In South Africa was a car accident and both her parents were killed. The family took her in without any court proceeding, and when apparently they told her mum's brother took her the wife didn't like her, and she was placed with other family in Clarence. She had the most appalling life as a young child, a teenager, and a young adult. She never got any documentation. And when she asked the family about it, they duck and dived, because we suspect that there was some road accident funds paid out. Maybe there was also another deceased estate of both parents, and they didn't want this child to inherit. Anyway, so Grandma ended up from Clarence in Johannesburg, lived in an informal settlement where 4 families shared the same space of 1 plot. Her teenage daughter, before she got 16, got pregnant. The mother only realized that when the teenage mum was 7 months pregnant. And this mum, the grandmother, of course, as we all know, became the guardian of this child, and she put this child up for adoption. She also wanted to protect her child, and she tried to get interdicts, domestic violence protection orders. She wanted the state to prosecute the man who was 20 years old of statutory rape. And then when the children's court asked but both of you are not documented. Is there a father? Of course there is. Where is he? And they traced the father, the social worker, because the granny didn't want to tell them. And of course, the father and his family said, yes, it is my child and I will take this child. And then the granny said, no, 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 you can't do that. And she wanted to withdraw the child procedure to give this child up for adoption. Now that didn't work because they were not documented. We also, well, we didn't. She herself went to the South African Human Rights Commission. They started with their investigation. I never knew whether it was completed, but the granny, we appointed a lawyer for her, a lawyer for the teenage mum, and a lawyer for baby B, because we knew there was a conflict of interest. It took quite a few months, more than a year, before all the investigations were done, and then the child was indeed placed with the father and his family, and the granny and the teen mum had rights of contact, and of course that will be reviewed as soon as they got documented. Now, the teenage mum didn't want to testify against the father because they were in a love relationship, and the grandma could never accept that. At least we got baby B documented. That is the good news to this, because the court said, but you are the father, we identified you, and we don't, even if it was statutory rape, we don't need a criminal court to rule on it. We must decide what is in the best interest of the child. And they ignored in the children's court statutory rape, and the criminal case never proceeded. Quite an interesting case with all these parties involved, and the criminal law also playing quite a role in this. The next case is, oh yes, and then of course we don't know, because the grandmother didn't want to speak anymore to us, and she didn't take any calls and so on, so we don't know whether this organization, South African Human Rights Commission, was able to resolve the case. We may even follow it up just for the sake of interest, because our main deal was to look after baby B. Then we have the cases where the grannies, and it's always the grannies, about 10% or 5% is the grandpas, but the grannies end up with the children. And even if their child, the mother, is documented, that mother disappears, and she's nowhere to be found. And the granny now wants to document this children at least. Now we have to then do the maternity tests, not the paternity tests. We go then to the grandma, have the DNA tests of her to link her then to the children. Many times, and this granny had 5 undocumented children. She's 71 years old. And then she has to look after children ranging in age from 13 to 2. You can just imagine the hardship not only she suffers, but also the children. She doesn't know who the fathers are, and her own child, even if she's documented, did not even supply her with, for 2 children, no documents. She doesn't even know where they were born, and the other 3 children only have a road to health card. So we are dealing with that one. Then there is a South African daddy, let's call him Daddy D, with 3 undocumented children from an undocumented South African mother as well. Her whereabouts unknown. This father had quite a journey. And now he's at that point where the Children's Court ordered, in terms of section 46D, 46 1H8, the Department of Home Affairs to assist and to issue the children with real birth certificates. And of course, they are ignoring it. We wrote to them with a letter copied to Mr. Matthews in Pretoria. He's our go-to director there. But at this stage, nothing has been issued, and we will take this further. And if we have to go to court to get a declarator, we will have to do that. Quite interesting, the father changed his surname. So one of the children's got his old surname, one child's got his new surname, and another child's got the mother's surname. So we have to explain this, but this is what it is. And if Department of Home Affairs can prove something else, we will be happy and we will accept that. But then, you know, if they can't, they can't. Case 4 deals with another very interesting case, and I'm going to conclude this. And I think these 4 cases indicate to you the plight of people in this world. This is a South African white man. He was born in 1963. He left school, Standard 8, the old Standard 8, grade 10, and he went to the army. He came out, he found his way to Joburg, and then he became a lay preacher. He did a good work, but he was robbed of his documents, his bag where all his documents were in. And what is that? Your ID document, and perhaps a birth certificate, because he's a poor man. And they threw acid into his face, and he tried to protect himself and his eyes. He has to wear, even today, dark glasses. His fingerprints were burnt off. He spent in hospital for months. He also now is a terminal cancer patient. This happened in 2004. He had such a shock. He only remembered his name and his date of birth, and the place where he stayed with other people. And so the challenge for him became to have his ID document reissued. Since 2005, I think, when he left the hospital, he has been going there and nobody wanted to help him. Remember, he was a child taken away at birth from his mother, and he grew up in homes all the time. And when it was time for school, they sent him to Jimmy Roos school in the Free State. And that is where he grew up and had his schooling. So he came to us last year. And we said, well, the social justice element is so strong, we at the OK department, who's dealing with children, will take your case on. And we had endless telephone calls, letters, trying to make way. And we just felt that the DHA could just have taken his names, his birth date, go into the system, and they must have found him somewhere, somehow, because he think he knew the names of his mum and dad. But then we had the bright idea of calling the school. And it took quite a few weeks. A social worker helped us there, and they sent all his documents to us. And we went through it. There was a birth certificate, and then on the one page where the school principal released him from school, there was an ID number. And that was still with the last numbers 005. It could have been 007. Anyway, we then submit that with a nice letter to the DHA asking them now please to help. issue temporary ID documents while we wait for the ID card. They did so, but let me tell you, even to get the final ID document on the 24th of September last year, he was sent from Johannesburg to Bell, Bedfordview to Edenvale. And this man has no means. And he walks from Jeppystown to Charlotte Makeke for his treatment. You walk to Bedfordview, you walk to Edenvale. And if we can just have that perseverance also like this client, I'm quite sure we will make quite a bit of inroads. Thank you very much. I don't know whether you have any questions or whether you would like to move on with the program. We can always stay after it was concluded to answer any questions. Thank you.
Thank you. Up next, we are going to be looking at blocked ID documents. Thandeka will explain the legal procedures and consequences. Oh, Balesa. Oh, it's Balesa. Okay.
Okay, yes, so as Tanya had explained, I'm going to be walking through blocked IDs. I don't know if any of you have been familiar with what's been going on with our case or even just the practice itself that's been going on nationally, really. And I think it's also going to be a great continuation in just looking at some of the contributors towards statelessness as an issue itself. And looking at ID blocking and the legal basis for it and some of the consequences of it. And I'm going to do it through presenting it through a case study, through the application that we brought to the High Court. So what is ID blocking? So ID blocking mainly refers to a process that's administered, or that was administered by the Department of Home Affairs when a person's ID is blocked or a marker is placed against their ID number on the National Population Register. So what this does is that it then renders the ID unusable because the person that's in possession of the document can't use it, right? So for example, if a person wants to open a bank account and then they give the bank their ID to prove their identity, the bank will obviously go within their systems and a block will come up because it's linked to the National Population Register, right? But then the bank cannot use that ID to open the bank account because the ID has a marker placed against it. So the person or the individual whose ID has been blocked usually would then have to go to the Department of Home Affairs and go to a local office to then find out the reason as to why your ID has been blocked. And so over time, the Department of Home Affairs' ID blocking practice became increasingly arbitrary and affected a growing number of people. In December 2020, I think the Minister of Home Affairs had revealed that the Department of Home Affairs had nearly 1 million blocked IDs within their system. And that encompassed duplicate IDs and suspected fraudulent IDs. So within the past 5 years, we've assisted a number of people with this issue who discovered that their IDs had been blocked. But none of them had been aware that their IDs were blocked until they attempted to access another service. So, example, trying to apply for a passport or getting new IDs, in renewing their driver's license, opening a bank account, or even just applying for a social grant. So they discovered the issue quite literally by surprise, with no one receiving prior notice of the department's intention to block their IDs or even just to investigate their status. And more particularly, they never received written reasons for that decision either. So if we look into why did the DHA do this? And they framed the practice as an administrative tool that they needed to do, and that was necessary in order to maintain both the accuracy and the integrity of the National Population Register, and so that they could also combat any suspected fraud or manipulation, which we've also agreed is in justified intention for state security, right? But we condemned the practice in that the ID blocking became increasingly arbitrary with the criteria that they used, which was very subjective and discriminatory. Because the DHA's reasons for blocking the IDs really looked at a host of things and included just looking at the shape of someone's inoculation mark, for example, or if there was a record of an affected person who did frequent cross-border travel. So if you worked in logistics, for example, as a truck driver, obviously you'd have to go, between different states. They would have alleged deportation records, or even if you had an inability to speak a specific local language, right? Or if you had a foreign-sounding name. These are just some of the reasons that we were given by clients. Or having a parent or a spouse that had a foreign descent. Another point of contention that we had with the practice is that the department didn't allow for a fair administrative process beforehand, or before blocking the ID. Many of the IDs had markers placed against them, which resulted in the ID being blocked without any notice, without any reason, really, or being told as to why, or being able to give the opportunity to represent yourself and explain to the DHA. So a big question that we usually get here is that, okay, but then what do we do with the issue of, fraudulent IDs? There are people in South Africa that may have fraudulent IDs. What do we do in dealing with that? And so we don't necessarily take issue, right, within the intended purpose of looking at state security purposes. But the mechanisms that have been implemented are unlawful, right? There are other mechanisms that could be adopted, or any other provisions, for example, in our law that the department could use in tackling the issue of fraudulent IDs. And even within their own papers, the department conceded that the IDs were blocked without any just and fair administrative processes being done, and that it was inconsistent with the Constitution. But it also informed the court that, no, we've developed our own procedurally fair and transparent system that they're trying to implement, but that system still entails placing markers or blocks within the IDs. And you have to wonder as to why, the issue has gone on for so long, really. And I think it's because the practice has also been inconsistent across local offices, local DHA offices across the country, which leaves a lot of cases remaining unresolved for many years, and for really two reasons. Because firstly, a lot of the clients or affected persons can't produce all the required evidence that they may need, especially those that may have an unregistered birth or parents who are unregistered. And again, that's due to some ineffective civil registration system for Black South Africans, really. And secondly, because the DHA claims that, okay, we have a 6 to 8 week processing time in investigating the status of your ID and how it was acquired, but the majority of the affected persons experience quite a lengthy delay and often wait months and even years for some sort of resolution. So why did we decide to take the matter to court then? We've represented over 100 clients whose IDs, some are still currently blocked or were blocked. And we contended that the DHA's ID blocking practice really just reflects a contempt of people. And their process really just undermines the sanctity of the Constitution. The practice is unconstitutional, it's unlawful, and it really infringes on numerous human rights, including, again, the right to citizenship, your right to just administrative action, and your right to human dignity. So the application in the matter of the official citation is PPM versus the Minister of Home Affairs, Pindile Mazibuko. And it was initially brought forward by this individual applicant who had lived in South Africa since 1998. But she then had her ID blocked by the Department of Home Affairs and was also under the threat of having her permanent residency revoked. And so we applied as ourselves, as well as LegalWise, applied to be joined as applicants within the matter, as a matter of public interest, and to have our clients' IDs unblocked. We also had the Children's Institutes admitted as a friend of the court. And so as applicants, we really argued that the practice of blocking IDs was unconstitutional because it left the affected persons in a state of statelessness, really. And in our papers, we really highlighted that it effectively prevents those from engaging with the world. Again, meaningfully engaging with the world, because they become ghosts within the system, right? And again, because the DHA didn't follow fair administrative processes before blocking, as per the Promotion of Administrative Justice Act, and give notice to the clients and allow them to make representations to plead their case. And again, there actually presently lies no real empowering provision in law that allows the DHA to undergo this practice, right? They can cancel an ID, the DJ can cancel it, but not place a marker and effectively block, right? So what the judge's finding was, in that on last January, the 16th of January 2024, the court declared that the Department of Home Affairs' practice of blocking IDs was unjust and irregular administrative action that is inconsistent with the Constitution. And more particularly, Honorable Judge van der Schyff said that while the Director General had a responsibility to protect the integrity of the National Population Register, by placing a marker against any suspicious ID without following just administrative action is unlawful. And again, the DHA would also, when we say a suspicious ID, the DHA was working on a reasonable suspicion. If we had a reasonable suspicion that you got this ID fraudulently, then they would block it, right? And so she confirmed that this mere suspicion that an ID was fraudulent didn't justify placing a marker on it and blocking an ID unless it was authorized to do so through a court order. So following that, the department was ordered to determine whether the unblocking of the ID documents of the current clients will constitute a security risk and determine the status of our clients as well as LegalWise's clients. And they were given 90 days to do that. Moreover, the declaration of invalidity, right, on the practice was also suspended for 12 months in order to give the department time to comply with the order, right? An important point that I want to highlight from the judgments is also that they had stated that there's an active violation of human rights by the state that infringes constitutionally entrenched human rights violations, and that then violates public trust, right, within the institution of a state, and again, undermines the Constitution. So what we had hoped is that the judgment would really hold the department to account for their conduct, first of all, and also acknowledge their role as a state entity to realize and also protect the rights of their citizens. And in any instance, if a mark or blocking had been done, that our hope is that the DHA would have at least followed the correct legal mechanisms in doing so, and in their conduct. And as highlighted in the judgment, do it through a court order. Now, the case has been very convoluted, and there's been a lot of developments that have happened since it was handed down last January. So I'm going to try to provide an overview that makes sense for everyone. But again, what does the ruling that we do have mean for affected people? And I think it was a success and a great first step in enabling everyone that was affected in getting their lives back and getting their dignity back, right? A lot of these clients have waited really patiently for a resolution on the matter, and hopefully have now gotten the opportunity to access the services that are so crucial for their citizenship and a part of their daily lives, really. So applying for a new ID, applying for passports, etc. But again, the true measure of success in a judgment doesn't just come in getting, having an initial order granted, right? But it's in the true enforcement of the order and in the implementation of the judgment itself, which is why it's really important to continue monitoring the status, you know, the real practical reality of that your clients are still facing post the judgment. And I think the nature of the relief that we had sought also allowed for this check and balance to happen with the DHA, to hold them to account through a supervisory order. And so a lot of the developments that were made following the January order last year were also made within the transition in government that we had and following the election, and in using the court to enforce compliance. And so following the order, we had submitted a list of all our clients to the DHA. And again, the DHA had 90 days to lift the blocks on the IDs. But instead of that, the DHA, as part of their practice or investigating, they decided to issue PAJA letters to each individual. And we highlighted to both the DHA and the court in that these PAJA letters were still flawed for a number of aspects. Firstly, that their reliance on it is misplaced. And it's also, again, an attempt to frustrate full compliance with the original order, right? And also to sort of intimidate some of our blocked ID clients, because there was a threat in complete erasure in the National Population Register if they didn't come forward and make these representations. Secondly, the letters were also dated and signed much prior to the handing down of the judgment, right? And so it doesn't actually reflect the spirit and the content of the court order that was handed down. And finally, the letters also erroneously place a burden of proving the legitimacy of the ID on a client, when it's really the DHA that has the burden of proof. Where am I? I've even lost myself. Okay. So again, a useful tool in monitoring our, the compliance and enforcement of the court order is through the use of these case management meetings, where we come together as parties and also talk to the judge and let the judge know, like, look, this is what's actually been happening since you've implemented. Where do we go here? These are the new issues that have sort of arisen. And so following that, the DHA then said, well, we're going to apply for an extension application to extend the 90-day period for us to really investigate the status of your clients. Following that, we then stated our intention that we were going to file a contempt order against the DHA for failure to implement. And we were really forced to return to the court to highlight the DHA's non-compliance with the January order. And so following that, I think 18 September, we heard the contempt application as well as the extension application simultaneously. And while the court didn't find that the department was necessarily in contempt, they did confirm that the department had failed to unblock the IDs by the requested deadline, the 90-day deadline. And Fundescape had also ordered that the unblocking would have to now be completed in 20 days, et cetera, et cetera. So again, as I stated, the original January order had suspended the declaration for 12 months, right, to allow the DHA to give them time to investigate the status of IDs, to also get the court orders for those clients or affected people more generally in South Africa that they feel pose a security risk. Following that, the DHA in February, the 12-month period lapsed in 15 January of this year, right? The DHA then brought an extension application to extend the 12-month period, and that was filed on the 13th of February, sorry. And what they're requesting is that they seek an extension of the initial 12-month suspension for a further period of 24 months. So what that means is that they want to be given until February 2027 to deal with the process of investigating affected persons and also to obtain court orders to have some of the clients' IDs remain blocked. We opposed this application, which was actually heard yesterday, and the judgment was reserved in it, so yeah, we'll see where we go from there. So yeah, we have had a number of IDs that have been blocked since the January judgment. And we've been monitoring the status of our clients monthly, really, with updated lists and verifying the status of it. But I think this case is also just an example of how mechanisms, again, post-judgment, are really just as important to ensure full compliance with an order, right? And to see that this issue really is eradicated, particularly when it has such a wide reach. So, you know, whether it's done through a case management or just the establishment of a judicial mechanism to see how success could be achievable. I think it's also important that we have the interventions, again, of other human rights organizations and other, you know, human rights organizations, because it's incredibly beneficial in advancing other key arguments that could be done, and just highlighting how this isn't just an issue that affects the 143 clients that came to LHR, right? It could, there's clients, I'm sure, that are based in Cape Town that are facing the exact same issue, who may not just have the accessibility, really, to know who to reach out to. So again, following this, you know, while the case really was brought forward on our end to deal in finding relief for our clients and just more broadly in the public interest, we still get so many requests from the public for assistance, right? So many people writing in saying, hey, we have this judgment, we're still, you know, stuck. I've been without an ID for the past 15 years, etc., you know, and it's having an effect on my kids. My kids can't go to school, etc. But again, unfortunately, we don't have the capacity to always assist everyone, and more especially the 600,000 plus individuals across South Africa that are actually faced and affected by this issue. So in closing, I just really want to underscore the need that we need for a referral mechanism network, and coming together and seeing where everyone can fit in, whether it's regarding children and having the Centre for Child Law come in, or pro bono coming in with their legal expertise, and again, the commission itself. And so hopefully that is something that we can establish beyond this room even. So yeah, that's ID blocking in a nutshell. Are there any comments?
Just a question. So, client wants to go and open up a bank account. He finds out that their ID is being blocked. Has no idea. Goes to Home Affairs. Were they given reasons? Were they told this is, you know, the reason why your ID is being blocked?
Nothing written, right? And someone will tell you, you know, your surname could be, you know, Chauke, for example. Anything. Steenhe. You know, Chauke, for example. Sorry to use your surname. But, yeah, you must be Zimbabwean. And so how did you get this ID? It's all very on a ad hoc basis at the discretion of...
And so there was absolutely no investigation done by Affairs before this flagging, because now they want to investigate.
Exactly, exactly. While the block is there, okay, let's investigate. But now if we're saying, okay, let's keep the block in there, does that mean now people that have still already waited for 15 years, give us time, give us another further 2 years to investigate while you now wait until 2027? I mean, yeah. It is. It is. I don't know the thinking around it. Yeah. So you come forward and present to us as to why we should unblock it, as opposed to this is the reason as to why we blocked your ID in the first place.
Is there a declaratory order, sorry, I haven't actually read the case, which says that this practice is unlawful going forward, or they still continuing with the practice?
So that yes, that the practice itself is unlawful, but what they now want to do is, because it's been suspended, yeah, the practice really will go forward. I think it's going forward practically in the practical sense of that while they are investigating, the block is still there. No one can do anything, right?
But are they allowed to continue to block others?
Oh, no.
Not in the same process?
Yes.
You may now have to follow the
Yeah.
project process in order if they want to consider blocking any further.
Any further ones, yes.
So it's the the 2-year extension is in relation to the 600,000.
The 600 that are blocked. Exactly. I wasn't using the mic correctly, sorry.
So there's two parts of it. There's the contempt we're pursuing in relation to the list that we submitted, our list of clients. Then there's the extension that they've sought in relation to the balance of the blocked IDs, the 600,000. We need evidence for the contempt application, and we plan to file this before the judge gives judgment in the extension application, which she needs to do before the 28th of March, because otherwise the order lapses. So we are pleading for supporting affidavits from any organizations that are dealing with blocked ID cases, whether you want to submit an affidavit that speaks to your observations around the practice, the ongoing practice. The cases that the court looked at were those before November 2022, because Home Affairs claims that after November 2022, they've been following like proper due process. But I know that there are some cases after November 2022 where a person has still found out by surprise that the ID is blocked, and we need that evidence. We had stopped collecting new cases because of our capacity constraints and trying to focus strategically on the implementation of the order. So our evidence is very limited, but I know some of you, the Commission definitely has, because we refer cases, and so does pro bono. So please do consider engaging with us around a supporting affidavit to add that evidence. We don't want Lawyers for Human Rights to become the gatekeeper of this court order, because it's now impossible for other parties to intervene. But there is this gap where we can file supporting affidavits that then elaborate on what we're seeing.
Okay, thank you, Balesa. Our final session today covers citizenship rights for children born in South Africa. Elgene Roos from CDH will therefore walk us through the Citizenship Act. Welcome.
I'm not sure if it was strategic to put the corporate firm at the end, but it's fine. We love you guys. Okay, I know I stand between you and going home, so we're gonna make it work. Okay, so I'm not gonna go into the entire act. I'm just going to focus on 2 sections today. And the way I framed this presentation was really a rant, but I think Daphne started it off perfectly with the Department of Home Affairs. And I wanted to reference this case that was actually handed down last week in the Western Cape High Court, because the thread today was the conduct of the Department of Home Affairs, and their conduct actually acting as a barrier to anyone trying to access some type of rights. So this case was brought by an immigration law firm and 8 applicants. And essentially they were tired of Home Affairs gatekeeping, the process of clients being able to apply for applications in terms of the Citizenship Act and the Birth and Death Registration Act. And Home Affairs argued in this case that they need to sort of have a screening process, right? Which, yes, they do need to have a screening process, but this screening process effectively bars people from trying to actually submit the applications. And so what was interesting about this case is that Home Affairs came out the gate and said their screening process is lawful, whereas the applicants were saying that the problem is that from the security guard to the reception to the person at some random desk is making up arbitrary requirements, right? And Home Affairs was saying, no. There's effectively a checklist with every application that comes through our offices. And this, all our screeners are doing is complying with this checklist. But the court found that this checklist and the screening process effectively being implemented by officials in the Home Affairs office is actually actually constitutes gatekeeping because they effectively are almost making decisions on the merits of the application, which they aren't entitled to do. The applicants also argued that the only parties or the only people in Home Affairs who actually have the vested rights to make these decisions are in Pretoria, right? In our wonderful head office that everything disappears to. So these were the arguments. And I thought this case was interesting because we've now had to almost move away from arguing about a rights-based approach, right? We've been to the Con Court, we've been to the SCA, we've asked the Con Court to give content on certain rights. But what effectively is the problem at the moment is the conduct by Home Affairs. And how do we get around that? How do we litigate in a way where the remedy actually translates on the ground and people can access the right without having a lawyer present? That is the goal for everyone. So read this judgment, it's very interesting. It came out last week. The Western Cape High Court is brilliant. I miss it. Gauteng is a bit more conservative, but we fight either way. Okay. So we have these two provisions, right? Section 2.3 and Section 4.3. And we've heard about it throughout the day. And effectively, Section 2.3 was amended in 2010. Section 4.3 came about in 2010 through the 2017 amendment of the Citizenship Act. Now, Section 2.3 speaks about a child born in South Africa to parents who have permanent resident status, right? And Section 4.3 talks about a child born in South Africa to parents who are to foreign national parents who don't have permanent residence or South African citizenship, right? So these two provisions are essentially safeguards to what Palesa was talking about earlier, being at risk of statelessness, right? So previously, before the amendment in 2010, children born to permanent resident parents automatically got citizenship. But Section 2.3 changed that position, right? So the requirements essentially are that you must be born in South Africa, you must have stayed in South Africa all your life until the age of 18, and your birth must have been registered, as Daphne had explained, in accordance with the Births and Deaths Registration Act. And upon turning 18, you can then apply for citizenship. Now, these amendments came into effect in 2013, and that's when the fight started. Home Affairs was of the opinion, sorry, I'm changing my slide here, and so Home Affairs was of the opinion that, okay, Section 4.3 only came into effect in 2013, so therefore it can only be applicable to children born after 2013, meaning that the first Section 4.3 application that will be submitted would be 2031, right? And so we filed, I say we, I was at the LRC at the time. So we filed a case in the High Court, firstly challenging this interpretation and saying the intention behind bringing this provision into effect was the fact that children who were in the asylum system, who were born to undocumented children, were at risk of statelessness, becoming statelessness when they turned 18, right? And so this is a safeguard. It can't come in 18 years later, right? So, and secondly, we said there are no regulations. Whew, what a contentious issue. There are no regulations, so what needs to happen is, pending the Department of Home Affairs promulgating regulations to give effect to Section 4.3, accept applications on affidavit and decide the applications. The court was with us. The court said, yes, we hear you. It should apply retrospectively. Applications should be given on affidavit, and that this provision, Section 4.3, gives everyone who meets the requirements a right to apply for Section 4.3, right? Those are the 4 requirements. Okay, we're moving on. Then, the fight continues in Gauteng with Jackie Cassette. I wasn't at CDH at the time of this case. And I'm not going to go through the case in detail because I have 12 minutes left. But then we have Jose, which is another pivotal case when it comes to Section 4.3. Jose is a case that involved 2 brothers who were born to Angolan parents. And effectively, they applied for citizenship. The citizenship application wasn't acknowledged. There was back and forth trying to engage with Home Affairs, but eventually CDH went to court, right? And the case went to the SCA. And the SCA confirmed that when an application in terms of Section 4.3 comes before the minister, because of the rights given in Section 4.3, the minister doesn't have a discretion. He can't be like, oh, no, but I don't like this person because their parents did something, or they applied for a ZDP permit, which is also another contentious issue, right? It's solely based on whether the applicant meets the requirements. And so they set out 4 objective requirements and said if an applicant meets these requirements, the minister must then grant them the application, right? So we have these 2 judgments that couldn't be clearer, right? This is Section 4.3, and I'm going to talk about Section, and we also talk about Section 2.3, because our interpretation of which provision should be used to apply for citizenship is dependent on what the status of the parent was when the child was born, right? So sometimes, at the time an applicant was born, the parent could have been an asylum seeker or someone who had formal refugee status. But eventually, along the way, through certification, they then get permanent residence. They then can apply in terms of Section 2.3, but because their parent was a refugee, they can apply through Section 4.3. Home Affairs is very confused about these 2 provisions. They don't know whether they're coming or going, because as soon as they see an applicant whose parents has permanent resident status, they automatically reject them at the door and say, no, your parents have PR status, you need to go and apply for PR. But the law doesn't state that. The law states that if you were born to a parent who has permanent residence, you are entitled to apply for citizenship when you turn 18. So what we've done practically is that we've sometimes used these 2 provisions together, and so argued that in terms of Section 4.3, because of this was the position when they were born, they're entitled to citizenship. In the alternative, we then apply for Section 2.3 citizenship. So that's what we've done, but I don't know whether Home Affairs has actually paid attention to that. So we have these 2 provisions, and we have these 2 judgments, and the law is clear on what it is, on who is entitled for citizenship. But Home Affairs comes swinging, and they say they're going to make this the most difficult process for anyone to get through, right? And so what effectively happened is that there was first, Home Affairs didn't know, Home Affairs officials on the ground didn't know about these provisions. Then the higher-ups in the department knew about it, they knew about the judgments, and they would engage. But because the local officers on the ground didn't know what was going on, you couldn't submit an application. And so there were different routes taken. First, applications were then submitted via email. Those were not acknowledged. Things went haywire. And eventually, Home Affairs then changed the position to say, no, we're not accepting, because the director of citizenship and travel documents said he lost control of his inbox, said, don't email me the applications anymore, go and submit it on the ground. The problem was that because there were no regulations, the minister, despite Ali, was not promulgating regulations. And this caused absolute chaos, because No one knew how to submit the applications, and when someone did want to submit an application, you had to have an affidavit from a lawyer, which is a barrier, because not everyone knows that they can access lawyers in these forums, and it shouldn't be the case that where there is rights vested in terms of a particular legislation, that a lawyer is needed, right? So essentially, we've been trying to engage with the Department of Home Affairs at every level, at local level. Miss Selina, who sits in the citizenship office at head office, with her, with the director, with the minister, with the DG, with the legal officer to the minister, I don't know, with everyone. But what we found is that there's too much chaos. And so we need to address this on a systemic basis. Because while the law is clear, the conduct by Home Affairs is a barrier. And so you'll see here that I've listed the conduct by the department at every stage of the application. When someone goes to the office and tries to apply, when they've submitted the long waiting. Once they receive a conditional approval, which in our opinion shouldn't exist because you can't conditionally give someone citizenship. There's no legislation or provision therefore, but that's what they've done. And even post-decision, when they say your application is successful, getting the ID, getting the naturalization certificate that they're supposed to give you. So there was chaos at every level, and it became very difficult to navigate this with clients. And so an application that should effectively take 6 to 8 months was taking years for some clients, and often with the assistance of the court. The second issue with Section 4.3 and Section 2.3 is that the department, the minister, has not effectively promulgated regulations. And I'm going to talk you through this. So, last year, I'm still in 2024. In 2023, regulations were published by the minister. Horrible regulations, very problematic regulations. Regulations that were gatekeeping, again, the process and the access to Section 4.3. But 3 weeks later, he then withdraws these regulations and issues a notice, right? Saying that I'm withdrawing the 12 June 2023 regulations, and he then attaches a set of regulations attached to this notice, and he says, I intend to, under Section 23, make regulations, right? So we thought, okay, he's withdrawn the regulations, he's now posted these regulations, which he intends to promulgate. And so again, effectively, we're in limbo, right? There's no process. I think through a Q&A session in Parliament, we find out that the minister says, no. I am in compliance with the Ali judgment. I've promulgated regulations. The 7 July 2023 regulations are in place. Absolute chaos. So that's what he tells Parliament. Yet there are no forms at Home Affairs offices which are attached to the regulations. The requirements are being implemented at an ad hoc basis depending on which office you go to, who you speak to at the office, their mood on the day. So nothing is clear in this process. And so what do you do when you've tried to engage with Home Affairs at every level, when you've been to court, when you've gotten the court orders, where you're trying to fight for compliance with the court orders? Essentially, you need to deal with a systemic issue, right? Which is Home Affairs itself. So, yes. So last year, together with Lawyers for Human Rights, we launched a big behemoth case against the department. And we specifically focused on Section 4.3 because there's jurisprudence already, because it was seemingly more clear-cut than introducing Sections 2.3 and issues with Sections 2.2 as well, but we focused on Section 4.3. And the relief that we seek in this application is very layered because of all the compounding issues in dealing with Section 4.3 applications, right? And so at one level, we ask for declaratory relief, right? That deals with the fact that the Department of Home Affairs has not complied with their constitutional and their statutory duties, and they haven't complied with the Ali and the Jose case. And they've also failed to promulgate regulations, right? So in this application, we argue, because of the language used by the minister in the notice, there are effectively no regulations. So we understand that the court may take a different view and say, no, but these are in place. And so we then ask alternatively, if the court is of the view that these regulations are in place, we then ask that they be declared invalid and unconstitutional and effectively ultra vires Section 23 of the Act. And so the provisions that we've asked to be declared unconstitutional ranges from the type of documentation you need to submit, which is, the first document they want is the proof of birth, which is very confusing because Section 4.3 requires that your birth must be registered. Now, if you've ever registered a child's birth, you need to have the proof of birth from the hospital, right? And that proof of birth must be submitted to the Department of Home Affairs to get that birth certificate. So effectively, Home Affairs has the proof of birth, but they want you to come with a copy of your proof of birth. This is the issue. And the hospitals, I'm not sure about the rest of the country, have been having a field day with us where they are now charging clients for this proof of birth, which is also another issue on its own, right? Another document that they want submitted is your grade 1 report. And this is stated in the draft regulations. You need to speak one official South African, sorry, one official South African language. The list goes on. But effectively, what the regulations also do is they restrict who can apply for citizenship as well. So if you are a child born to parents who are documented, who has a valid permit, you can then apply for citizenship. But what it doesn't allow for is applicants whose parents are actually undocumented, or someone whose parents are documented, they're an asylum seeker, but they couldn't ever join the file of their parents. And effectively, the only document they've had is a birth certificate. The regulations don't account for this situation, and so it therefore almost restricts and changes the requirements of Section 4.3. There's a lot of problems with the regulations, but we ask that they be declared unconstitutional. Then in terms of mandatory relief, we also ask the court to engage in a consultative process if the court finds that there aren't regulations, that they engage in the consultative process and that they actually promulgate the regulations within 12 months. But if the court was of the opinion that the regulations were in place, we then ask that the respondents amend the defects in the regulations after engaging in a consultative process, and pending the promulgation of the regulations or the amendment of the regulations, whichever the court then orders, we also ask for a directive to be issued where Home Affairs clarifies what the process actually is for submitting, for adjudicating, for processing the Section 4.3 applications. We go in detail as to what information should be contained in the directive so that they can be held accountable to a process, because this is the problem now. Randburg, Harrison, Barrack Street, Belleville, they all have different requirements. They all want different documentation. Some Home Affairs officials want to verify and certify the supporting documentation. Others want proof of birth, others want the parents' documentation. So this is the problem. And so and we also ask for supervisory relief, where Home Affairs has to then report to the court within 30 days first, and then every 3 months thereafter. So effectively, we try to do a lot in this case, but it's because there's been such a history with this issue, and because the law is clear. And so what we effectively want is for Home Affairs conduct to be taken to task, and we hope that the court is going to be with us on this. At the moment, we are still waiting for Home Affairs to oppose our matter or not oppose our matter. We don't know. We're trying to find out what the instructions are. But I think we've spoken about this today. And I think more than us litigating on legislation, etc., we need to deal with Home Affairs and their conduct and the officials on the ground. Because it cannot be that if I have a vested right, that I have to justify that right from the security guard to everyone else through Home Affairs until my application is decided. I will end there. I went 5 minutes over. Thank you. 2 minutes for questions. Comments?
Comment. So I obviously am in criminal litigation, and I always used to think the worst of SAPs for what I systematic violations of constitutional rights, everything. But after being here today,
yes, 100%.
Sorry, and I think I'd get back to the comment or the question I asked at the beginning in response to the first session is this just sheer maladministration or is it intentional? And I really think it's a combination of both. In relation to the citizenship issues, I think it's intentional, quite frankly, because there has been an intentional, determined decision not to process. And if you then go and understand what government is suggesting or wanting to do in the white paper that I think Palesa mentioned, effectively they want to do away with Section 4.3. So this is the intention, is to subvert, prevent application, do away with the right. And that's as far as they're prepared to go, and it's very chilling because you start with Section 4.3, Section 2.3, whatever, but where does it end in relation to, and we're not just dealing with asylum seekers' rights or permanent residents even, we're dealing with the right to citizenship in the context of a country where we have, we've done this before to millions of South Africans, and we're attempting to do it again, not as dramatically and not to the same extent, but it's as arbitrary. It's based again on arbitrary grounds. So it's a very, very serious issue, this, and I think part of the reason why we also wanted to institute this case at this time in such a systemic way is because our real concern is that there's going to be a class of people who, if they unless they're putting their applications in there and are actually trying to enforce this right before they do away with this right, you could have a class of people whose rights to citizenship is being wiped off the law books.
So we will be putting out more advocacy material out there, and would appreciate if you can also support, share, just publicize the message, bring sensitization to the issue in this climate of anti-migrant and ideas about who belongs and who doesn't belong.
Thank you for a very informative session. I think speaking maybe in the context of legal aid, South Africa, we are strategically positioned that we can do more if we are capacitated to do more. Because currently what I see maybe as a challenge is originally it was designed to do criminal. So civil came in as something secondary to what we are doing, which is why criminal is even in Chapter 2 of the Constitution, but there's no civil provision in the Constitution, so it remains a privilege. I think maybe also because we'll need a policy shift in terms of what we are supposed to do in terms of our mandate. I know with Children's Matters, Children's Act itself allows magistrates to make orders compelling legal aid to come in and represent the child, because the two parents will be fighting in the matter. So there we have no choice. We are being compelled. We come in, we represent the child, irrespective of whether the child is South African or non-South African. But I would suggest that maybe also our national office, you engage, it starts from up there, because it's easier if it all starts there and then it goes down, in terms of whether we go via the route of memorandum of understanding or we do other collaborative efforts in order to assist. And also to suggest that the material, your slides for all the presenters, please, if you can share with us and email, if it's possible. Thank you.
In terms of all lawyers being required to do 40 hours of community service, one of the arms in which the regulations anticipate that can be done is through legal professionals assisting, for example, state entities, including legal aid. And I think something that we really need to pursue within the profession, and I would love to have conversations with you, not just because of, for my own firm, but because I think it's a really important opportunity where we could be providing more opportunities for people to be doing meaningful work, is how the profession can be working with legal aid to be facilitating, working together with legal aid, through this community service regimen to be making access to justice more meaningful for people in the civil context. And maybe, that requires a discussion with your bosses, but any thoughts that you had on that, I think would be really useful. Thank you.
Maybe just to comment, we do have the pro bono program where we collaborate with other private practitioners who gets to be registered on our database we allocate matters, they do community, or they do work for us, and we give certificates for compliance in terms of community work. But there are other areas where we are struggling. Even just last week, I wrote a letter to LPC because we are dealing with an estate matter where I need a conveyancer. But I need someone to come in and assist there. But it's a challenge because, like where I'm coming from, Nelspruit, we are bordering Swaziland and Mozambique. Immigration is a problem. I think people have found an easier option, which is just coming to South Africa. You stay before 30 days, you go back, your passport is stamped, you come back. So some people are living in South Africa literally for years now, using that system now, because they are trying to run away from other channels of Home Affairs. But you are right, I think National Office will be better positioned to assist because they can change.
All right. This concludes our symposium for today. Special thank you to all the speakers and all the participants for all your insightful contributions and invaluable thoughts. Before we can all up and leave, just 3 things quickly. Firstly, the register. Please ensure that you have signed the register. And then secondly, we would like to take a picture just outside the training room. There's a banner. And then lastly, if anyone does have time, we would really love to do a quick interview with the crew. It's just about today's symposium and what was your take from the symposium today. Thank you everyone for attending. We really do appreciate all your contributions, and have a great day.
Hello, my name is Aldrine Ruiz. I'm a senior associate at Cliffe Dekker Hofmeyr in the Pro Bono and Human Rights Department. My takeaway from today's symposium is that If we collaborate and if we work together and engage with each other and learn from each other, we could be a powerful force in trying to realize the values and the rights entrenched in the Constitution. I think today was very valuable in terms of getting insights into what everyone is doing and how we can work together. And I think as a corporate partner, it's important that we support and we provide resources to ensure that vulnerable communities and vulnerable persons have access to justice.
I was invited to the symposium because we at Pro Bono run legal clinics. We registered with the LPC and we have a lot of interest in this particular matter because we have a dedicated refugee clinic that works with the plight of the vulnerable in the sector.
Hello, I am Andile Msane. I am a human rights officer from the South African Human Rights Commission. My takeaway from today's session is that there are a lot of legal practitioners who are interested and want to know the law. So it is important for us to then ensure that we have a lot of information sessions where we capacitate one another and we ensure that we have collaborative sessions such as this. Going forward, it would be important for us to have a collaborative efforts with other organizations who are possibly not invited today, because the session is going to be across provinces. So if there are organizations interested in migrants' rights and human rights, it would be a great opportunity for everybody to collaborate to ensure that the information goes far and wide to ensure the realization and the protection of migrant rights.
Hi everyone, my name is Daphne. I am a legal consultant at probono.org. I'm so excited about what happened today, to see all the legal practitioners in one room, sharing a common ground, sharing the rights of everyone, wanting to change and to correct all the human wrongs that are being done to the vulnerable. And I am seeing that we still have a lot of challenges when we are dealing with people on the move that we need to correct, that we need to collaborate on. And we also need to ensure that we work together with the departments, the policymakers, all the stakeholders, to ensure that everyone comes on board and we deal with the challenges as they come. I believe that together we can do this, and eventually we are going to ensure that the rights that we have in Section 28 of the Constitution, which says every right has a right to a name and to an identity and to a nationality, are being upheld. Thank you very much for doing this for the vulnerable, and we hope we are going to leave footprints and change their lives out there.
Hi everyone, Fortunate Mungwai here from the Center for Child Law. My takeaway from today, I think today was a success day in relation to the discussions in the room, because what was important for us to realize was that everyone is coming from different backgrounds pertaining to the work that they do pertaining to migration issues. Specifically with us as Center for Child Law, we do the work relating to birth registration as well as migration, and the issues raised in terms of unlawful detention of children, as well as the challenges faced by citizens in relation to birth registration as well as citizenship. I think those were some of the challenges in which needed to be addressed, but how we can address them, I think, is through collaboration between different stakeholders, be it the Department of Home Affairs, be it the Department of Social Development, and be it the Department of Education, to ensure that every single child in the Republic has the enjoyment of those rights that they're entitled to, irrespective of their nationality or documentation status when they're in the Republic. And I think what was important also to take forth was the fact that the lack of implementation of existing judgments as well as existing legislation is the thing that really causes a lot of problems, that ensures that everyone will have access to services that are available to everyone. So it's very important for us to ensure that there is implementation of court judgment as well as legislation, and also just strategic collaboration amongst different stakeholders, and again just ensuring that we during the workshops, it's not only civil organizations that attend these workshops. It must also be various departments, so that we can also try to get a sense of the processes and procedures when they do processing of birth registration, or when they do processes of ensuring that a child has access to citizenship or access to education in that regard. So I think it was just very important to learn from one another and to keep on the motion going. It mustn't be a thing whereby we come to workshop and we talk and we don't put the work in action. So there is a need for us to know to act on what we said here today, and I think it's just very important for us to just continue working and to ensure that every child in the Republic, has enjoyment of their rights, but overall, just everyone within the Republic has the enjoyment in the Constitution. And I think it was just very important for us to, take away a lot of learnings and so forth. So I think, today it was a success, and I hope that we will have this many engagement going further just to ensure that we do bring forth, the word to the public in terms of their importance of their right being respected.
My name is Nyeleti from Lawyers for Human Rights. Really grateful for today's engagement. This was our first leg in a couple of legs that we'll be having with legal practitioners across the country. And I think this particular engagement was very successful to start off this journey of creating a network of legal practitioners where we do not work in silos, but where we are able to collaborate and also to work in tandem towards a shared goal. I think what I took away from today is the drive that stakeholders and private attorneys have in assisting in this work. It was incredibly beneficial to also have Legal Aid South Africa present today with quite a couple of representatives from across the country, as they are a focal point when it comes, or they are the first point of contact when it comes to marginalized community. So in essence, I think this engagement was successful, but it doesn't stop here. Obviously, there needs to be more engagement, advocacy work. Please keep tuned to our social media to follow all the advocacy work that we're doing, because ultimately we want to use litigation as a measure of last resort and start on the ground implementing some of the suggestions that have been mentioned, engaging with stakeholders and trying to impact people's lives directly through our interventions.
Hello everyone, my name is Tanya. And my takeaway from today's symposium is the fact that we were all able to identify the issues that we face in the space of migrants and refugees. As the partners who gathered here today, we were able to share all our thoughts, and moving forward, there will definitely be more advocacy and more litigation towards sorting out these issues. And I'm very glad that we were able to embark on this journey. And moving forward, we know that there will be more symposiums. Thank you.